And oops. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Welcome to the Appeals Court. It's my great pleasure and privilege to be sitting this morning with Justice Neyman and Justice Lemire for this argument in number 2019 P1068, Commonwealth versus KASHIF Scott, which we're conducting by Zoom because of the ongoing pandemic. Although we're doing this in this format, the ordinary rules of argument apply, which is that each side gets 15 minutes to argue and there is no rebuttal. And with that, Mr. Madison, are you ready to go forward?
I am, Judge.
Thank you.
May it please the court, Nick Madison for KASHIF Scott. This case is controlled in all meaningful respects by Commonwealth v. Couture, and that case held that a report of a man in a store with a gun in his pocket does not constitute reasonable suspicion of criminal activity. The report in this case is substantially identical to that of Couture. In this case, a store employee reported seeing a man with a gun in his pocket in the store. Because the evidence developed at the evidentiary hearing does not reveal any additional indicia of criminal activity in this case, there was no reasonable suspicion of criminal activity, and the stop of Mr. Scott was erroneous.
Where did the stop occur in Couture?
In Couture? I may be pronouncing it wrong, so I'm not meaning to correct you, Judge.
That could make two of us, so go ahead.
The stop in Couture, by my memory, the call was of a person in a convenience store, but by the time the call got relayed, the person had left the convenience store, and the stop happened as a road stop of the car after the person had left the store.
So is there a difference in terms of public safety when the stop occurs when someone is constrained in a vehicle outside of the public, and the stop or seizure occurs inside of a public place where a named caller has made a 911 call about a gun that is concealed in the back of someone's waistband, I believe? Do you see any distinction between those two scenarios? And I should say material distinctions.
Sure, Judge. And one clarification, the report here was for the caller reported that the gun was in, quote, the back of his pocket. The finding by the judge was in the waistband area, so it wasn't entirely clear that it was tucked in the report was that it was tucked in the waistband.
Assume for the sake of argument that the judge's finding is not clearly erroneous in answering my question, okay? Sure.
And so certainly there are distinctions between somebody having a gun in the confines of the store and somebody having a gun potentially at a road stop. I mean, certainly there would be public safety concerns for the officers making the stop as well, but during a stop on the roadside. But I think the important factor here is if you look at the I'm sorry, I lost my train of thought for a moment. If you look at, I'm losing the name of the case. Narcisse, there it is. Narcisse and Menius, public, which rejected the proposition that public safety concerns from a firearm can obviate the need for a reasonable suspicion of criminal activity. The public safety concerns aren't the only issue here. The issue is there indicia that a person is carrying a gun in some way illegally or preparing to use the gun illegally? So where there may be distinctions between the public safety risks, that is subsidiary to the question of if there is a reasonable suspicion of criminal activity.
So let me ask you this as well. If the police, same facts, but instead of simultaneously asking the defendant if he had a license, if immediately before frisking him, they said, do you have a license for a gun? And he said yes, or sorry, he said no. Then the police could have frisked him. Do you agree with that?
Yes, if prior to seizing him, he had responded that he did not have a license and they had reasonable suspicion that he was carrying a gun, then there'd be reasonable suspicion that he was criminally carrying the gun, that he was carrying it unlicensed.
So same facts, except the police ask him seconds before frisking him, do you have a license for a gun? And he won't answer. And then the police frisk him.
So in this scenario, they ask him, there's not an immediate answer, and then they frisk him, if I understand this iteration. That would be a closer question, and I think it would depend on the factual finding of how long the delay was and whether the person had showed any nervousness, or that there might be a lot that would go into that. I think that would be an inherently fact-bound scenario as to whether the failure to respond immediately gave indicia of criminal carrying of the gun, unlicensed carrying of the gun. But in this case, because both the officer and the officer testified and the judge found that the asking of the question was simultaneous to the grabbing, the seizure in this case, it's clear from the record here that there was no opportunity for Mr. Scott to respond prior to the seizure in this case.
Is there a transcript of the hearing on the motion for reconsideration?
There isn't. There wasn't one prepared here. The judge, I believe, denied it in a endorsement on the motion.
But there was a hearing, right?
There was a hearing. I believe the motion for reconsideration is in my appendix, which essentially argues per couture and distinguishing the judge's reliance on Foster. So Mr. Scott essentially makes three arguments here. One is that there's certain clearly erroneous facts in the judge's finding. The Commonwealth has conceded some of those in their brief. I won't spend long on that, only to point out that the facts underlying the high crime area finding or characterization in this case, some of those facts are clearly erroneous. I don't believe the Commonwealth has conceded on those facts. The judge cites numerous calls for criminal activity. There was no testimony about any calls for criminal activity in this case. The judge refers to calls for narcotic sales. There was testimony about one or more arrests for narcotic violations. So there are certain clearly erroneous facts underlying the high crime area characterization in this case. But the substance of the appeal in this case is whether or not the facts create reasonable suspicion of criminal activity from the carrying of a gun. We know from Couture that the mere carrying of a concealed weapon does not provide reasonable suspicion of criminal activity of any crime. The Commonwealth here makes the argument, which I alluded to in answering Judge Neyman's question, that carrying a firearm in a public place is a public safety risk that justifies, even in the absence of reasonable suspicion of criminal activity, justifies a stop and pat frisk of the person. And suffice it to point out that the case that I couldn't come up with before, Narcisse and Menius, have clearly rejected that line of reasoning. And Menius actually went further and noted that Foster, the case that the Commonwealth cites at length in their brief, should not be used for the proposition that a stop may be made in the absence of reasonable suspicion of criminal activity due to the public safety risk associated with firearms and firearms carried in public. So I would suggest that that argument has been clearly rejected by the Supreme Judicial Court.
Madison, do any of the cases you cite involve a fact pattern like this one? It seems that most of those cases involve a motor vehicle stop, an anonymous tip. Are there any cases that involve a 911 call where the police arrive and it's from a named person, it's in a public place, where the gun is, let's say, not secured in a holster? Are there any cases with fact patterns more akin to this one?
So you're right, Judge, that a lot of these tend to happen more on the street, I believe, as opposed in the confines of a store. Couture, I mean, we already kind of talked about Couture and the distinctions there. The person was stopped once they had left the store. I'm not recalling seeing a case in a store context such as this.
The reason I ask is it's a bigger picture question, which is I understand the Couture line of cases, the language we've used, which is possession of a gun by itself is not enough to create reasonable suspicion. But the touchstone of Fourth Amendment jurisprudence is proportionality and reasonableness. And under these particular facts, in view of the facts which I just gave to you and that the judge found, I'm having difficulty seeing where the police did not act reasonably and where holding someone's hands for the purpose of securing safety to themselves and to the public in the store is not proportionate or proportional to the factual situation as it stands.
I certainly understand that concern. I think with—
And the answer may just be that that's why we have an exclusionary rule, but go ahead.
I think that is part of the answer. I think when you're talking about a firearm, the distinctions between the ability to wreak havoc and cause substantial bodily injury are significant when you're in a store. It's also significant if you're walking down the street with other people around, like a lot of people, like a lot of these cases fall into that particular fact pattern. I think it is important to note that because people do have a Second Amendment right to carry a gun, because there is a Class A license to carry that allows people to carry guns in public, concealed or not, that if we construed the Fourth Amendment in Article 14 to allow the stop and seizure of anybody with a concealed weapon in a public place, that would not only eviscerate the Couture, it would also impermissibly burden people's Second Amendment rights and statutory rights to carry guns in Massachusetts. So I think, getting to your point, that may be it may be that we have to allow for a certain amount of a public safety risk due to that.
So just to circle back to the question, though, do you agree that the police acted here reasonably and proportionately to the situation?
I would say not, because there's no indicia that Mr. Scott was prepared to use the gun or casing the location. Mere carrying a gun with no indicia of being prepared to use it doesn't strike me as reaching a level of justification to physically seize somebody. And I think if you look at the cases of the more recent case, which I cited in my 16L letter, Evelyn, police approached somebody. It was on the street, but they approached somebody they suspected they had a gun and engaged him in conversation, and were able to develop reasonable suspicion at that point to seize him. Same in DePisa. Police suspected somebody had a gun and walked up and engaged him in conversation and developed reasonable suspicion at that point.
Did those cases involve 911 calls from a known person that the person was indeed carrying a gun, or did they just involve more of?
Evelyn, I apologize, Judge.
No, go ahead.
Evelyn was in response to a shot spotter activation and then calls about a shooting that turned out to be fatal. I don't believe the police knew it was fatal at the time. DePisa, I don't, to be honest with you, recall if that was just the officer's observations or in response to a call. I would like to just hit quickly on, it's not, the Commonwealth alleges that this was carried without, the gun was carried not in a holster. And I would just like to note that it's not clear from the factual record of this case that it wasn't carried in a holster or otherwise secured, and just point the court to the case of Commonwealth v. Alvarado, where the SJC made clear that a report of a gun wrapped in a towel did not create reasonable suspicion. And finally, I'd just like to hit on my last argument in passing, which is the judge, we've been talking so far about the first prong of the Terry stop analysis, whether the stop was justified at its initiation. The second prong of whether the police conduct exceeded the scope of that justification was not addressed by the judge's findings. Here, the police didn't follow the prototypical Terry stop of a pat frisk, and so we would need those findings if the court does find the stop justified at its initiation. Thank you.
Thank you. Let me see if are there any questions, further questions? No, thank you. Ms. Burbine?
Sorry, I had to hit the unmute button. May it please the court, Carolyn Burbine for the Commonwealth. It's the Commonwealth's position that the motion judge properly denied the motion to suppress where the pat frisk was permissible based on the reasonable suspicion that the police had that the defendant was armed and dangerous. We had a call from a known caller, the clerk at the store, expressing concern about an armed individual in the store. And the Commonwealth's best case is Foster, which says that, which basically differentiates cases like this from the car stop cases and other cases, and says there's a consistent theme in gun cases that if the police reasonably perceive a danger to themselves or the public, they have a duty to investigate and may perform a pat frisk if they have a reasonable belief that the defendant is armed and dangerous. And here we had a legitimate concern for public safety. We have a man in a store with a gun in his pocket, back pocket, and the police come and there are people in the store, there are customers outside the store. There's testimony to that effect. And so the police did, the minimal, intrusion that they could under those circumstances, which was to take his hands, and that lifted up his shirt and the gun was exposed and they were able to see the gun.
Why wouldn't it have been, why would it not have been less minimally intrusive to ask some questions first?
Well, I think under the circumstances where, as the judge found, it's late at night in a liquor store, the caller has given a detailed description. So, we have him fitting the description right when they walk in.
The caller, I listened to the 911 call, and the caller says that the defendant was on his way out. He was checking out. He was on his way out of the store.
Right.
Why doesn't that make a difference? And the police asked him to see if he could detain the defendant from leaving. Is there any suggestion in the record that the defendant was about to use the gun? Had used the gun, was threatening anyone? No.
There's none of that.
Is there any reasonable suspicion of a crime present on the record?
Just that there's a possibility that he may not be licensed. I mean, he has a gun just in his back pocket. I think you have to take it in the totality of the circumstances, what the police knew. So you have an identified.
What would be the crime would be a possession without a license? Is that the
yes.
crime?
Or carrying without a license, possession without a license.
And what was the evidence to suggest that he didn't have a license?
Well, I think you can look at the fact that he, how is he carrying it? I cited Reyes, which states that there are federal statutes on guns. That was a gun storage case. But, to get a license to carry or an FID card, you have to complete a safety course. And included in that curriculum is the safe use, storage, carrying of a gun, methods to secure a gun, how to possess, store, and transport guns. So I think it's a reasonable inference that this gentleman was not a responsible gun owner and may not have completed that course, which I think added to all of the circumstances surrounding this situation. And you've got the public in the store, you have the clerk potentially in danger, the people outside the store if they let him walk out. And I also pointed to Macaulay, in which there was an anonymous call to a dispatch. And then the dispatch it was at midnight. The caller had given a full description of a man in a cafe, and the call was that there was alcohol served in the cafe, and the man had dropped the gun twice. So the police went in, and they saw that he matched the description. And because of his carelessness with the gun and the potential that he was intoxicated, he posed a danger to the patrons. So the pat frisk was acceptable. And I think we have a very similar situation here. And in fact, here we don't have an anonymous call. We actually have the identifiable caller who is in the store. So I think when you take all of the factors, I know there's a dispute over high crime area, but you've got 10:30 at night in a liquor store, gentleman in the store, clerk is concerned enough to call the police. You have customers in the store, you have the clerk in the store. The defendant is at the counter facing the clerk, so he's close to the clerk. And I think when you take all of those factors into consideration, what the police did was reasonable. I mean, it would be very quick for the defendant to be able to reach in that back pocket and just grab that gun. And the police, weren't willing to take that chance. So that would be our position on that, Your Honor.
You cite the Foster case for the proposition that, this kind of situation, not in a vehicle, but where there's public safety issues in a high crime area, is a little bit different than, let's say, couture. But the follow-up question is, haven't at least 2 SJC cases said, well, Foster may be a little bit different, don't cite it for the proposition that means a crime has been committed?
Well, I think what I like Foster for is that there's a case. It says that as long as there's a legitimate concern for public safety, the police can conduct a protective frisk even without direct information that he was had committed or was about to commit a crime. And I think that's important because the court also in Foster, rejected that couture idea that, it's just, what are the police supposed to do? I guess it comes down to, they have a call of a man in a public place and he has a gun just in his pocket, and you have, I don't think that there was an issue of proportionality here. I think that they did the best that they could under the circumstances. I'm not sure that they are supposed to have to risk, the public safety or their own safety when you just have a loose gun in a pocket.
Let's assume we agree with you. Hasn't Narcisse, though, already rejected the argument you're making?
I was under the impression, I apologize, I'd have to read Narcisse again.
And Torres Pagan.
Yes.
What do we do about that case?
Well, even with Torres Pagan was a car stop, again, not a man with a gun in a public place. So I think
right. I'm not worried about the facts on the factual scenario. I'm talking about what is the correct statement of the legal principle here. And as far as I can tell, it requires reasonable suspicion of a crime.
I read it as reasonable suspicion the defendant's armed and dangerous. And I don't think it overrides Foster. I still think Foster is good law in that you take all of the factors that you're given and you see if in the totality of the circumstances what the police did was justified and whether there was sufficient indicia that he was armed and dangerous, and I would posit that here he was, for all of the reasons that I stated previously.
Does armed and dangerous, is that in the conjunctive? In other words, there needs to be the fact of armed and the fact of dangerousness?
I think.
Does being armed, in your view, necessarily satisfy the dangerousness piece?
Well, I think I think you do have to prove the dangerousness also. I think
So here,
that's where I think the fact that it's in his back pocket and he's just in the store. And again, as I said, is it reasonable to believe that someone who's just carrying a gun around like that is a responsible gun owner and is likely to have the license to carry or the FID card? I think that's part of the analysis that the police can make and the judge can make. And here, given all the factors, I think that, I'm not saying it wasn't a close case, but I think it makes the grade, Your Honor.
let me see it. I think we understand your argument. Are there any questions? No, thank you both very much. It's an interesting case and your arguments have been extremely helpful to us, so we appreciate it.
Dave? Attorneys, can you hear me?
Yes. Yes.
Thank you.
Good morning. Welcome to the appeals court. Thank you very much for joining us by Zoom conference this morning for argument, which we're doing in light of the pandemic. Just a reminder that that you are at all times can both be heard and seen, so you want to keep that in mind, and that we are recording this and streaming it simultaneously on a YouTube channel, and that recording will be preserved for people to watch in the future, so that you know. Otherwise, the panel today, and it is my privilege to be joined by Justice Neyman. I would normally say on my right, but he is on this screen down in the lower left corner. I don't know where he is. I don't know where he is for you. And Justice Lemire. We observe the ordinary rules of procedure as though we were in the actual courtroom, and that means that each side has 15 minutes to argue, and there's no rebuttal. A clock will appear in the box where the clerk's symbol is now to help you keep track of your time. And with that, I'm going to call this case. It's number 2018 P 1624, Commonwealth versus Timmy Hunt. And Mr. McLean, or is it McLean? We're ready whenever you are.
Thank you, Your Honor. Good morning. May it please the court. Ian McLean on behalf of the Commonwealth. This court should reverse the ruling allowing the motion for new trial for 4 reasons. First, Judge Friesen allowed the motion for new trial without a hearing, let alone an evidentiary hearing, as is required. Second, Judge Friesen relied on an erroneous view of the law in allowing the motion, as she applied an incorrect legal test for what constitutes newly discovered evidence. Third, using the correct legal test, this material does not qualify as newly discovered evidence. While it may be newly discovered, it is not evidence, as it was not admissible had there been a trial. And fourth, the defendant made no showing on prejudice, that he would have refused the plea based on this information and actually gone to trial, risking the 7-year mandatory minimum that he would have been facing. So turning initially to allowing a motion for new trial without an evidentiary hearing, it's a well-known premise. We cited Gordon in the brief for this proposition, but you could also look to Sylvain or Campanano from the SJC, both of which indicate that a motion for a new trial can't be allowed without the Commonwealth being afforded an opportunity to challenge the assertions made by the defendant. And that's exactly what happened here. So, and the first and most obvious, glaringly obvious thing that I would point you to as an assertion that was made and went unchallenged in an evidentiary hearing would be the credibility determinations that Judge Friesen made regarding both plea counsel and the defendant himself. So I point you to her ruling at page 8, which you can find at the addendum, page 54. There she indicated the court credits his and his counsel's representations. They would not have accepted the guilty plea and would have proceeded to trial. So there she's indicating that she's made a credibility determination about both the defendant himself and about plea counsel. And there are two problems here. First is simply that you can't make a credibility determination on the basis of an affidavit.
Well, we do allow judges to make the contrary credibility determination on the affidavits, don't we?
Well, yes, potentially, yes, Your Honor, if the affidavit doesn't raise a substantial issue. So,
well, we say all the time, the judge can discredit the affidavit of the defendant.
Yes, Your Honor, but
without a hearing.
Correct, Your Honor, because the
So
judge
why
there.
is it that the judge can't credit the affidavit without a hearing?
Well, I'd point you to the first thing that comes to mind would be Justice Scalia way back in the Crawford case, referring to cross-examination as the greatest crucible and truth-finding mechanism. That's a very rough paraphrase of what he said in that opinion.
But that was an advancement of the defendant's Sixth Amendment right.
Yes, Your Honor. Yes, Your Honor. Not for the purposes of factual analogy at all here. Just the concept of cross-examination is what brings the truth to light here. So there are two problems. First is this. I'm sorry, Your Honor.
No, I was going to say, is it your position that the affidavit is limited for the purpose of whether it raises a substantial issue?
Yes, Your Honor.
And once that's been raised, the affidavit cannot be considered as part of the evidence of a hearing.
Absolutely correct, Your Honor. Mubdi is the clearest place where you would find that, footnote 4 in Mubdi. But you could also find that in Lawson from this court, which the SJC denied review of back in 2011 as well. I mean, it's a common and well-known practice that the affidavits provide the substantial basis to get you to the hearing and then are meaningless at the hearing. The witnesses have to testify so that the motion judge can see and hear them and make credibility determinations. I point you to Tremblay for that point. That's why the appellate courts defer to the motion judge, because they saw and heard the witness in front of them.
So this might be a refinement on your argument before, which is not that the judge couldn't credit the affidavit. The judge could credit it, but it could only get her so far as then holding an evidentiary hearing.
Yes, Your Honor. Yes, Your Honor. Absolutely. So then the second point here is that the second problem in what the motion judge here was, she made credibility determinations on not only plea counsel, but on the defendant himself. There was no affidavit from the defendant himself. There was only an affidavit from plea counsel. On the basis of that and plea counsel's speculation, and I point you to Commonwealth's appendix at 54, paragraph 28, that's the plea counsel's speculation as to what the defendant would have done if he had known this material. So the motion judge here made a credibility determination on what the defendant would do based on speculation from the plea counsel in an affidavit. So we're looking at layers of mistake there and things that can't happen.
What are you asking us to do by this appeal? To send it back for a hearing? Or, I mean, in your conclusion, you ask us to vacate the order and enter an order denying the motion.
Yes, Your Honor, that is what the Commonwealth is asking here. But at an absolute minimum, you can't affirm the judge because simply because of these credibility determinations alone. Like, the defendant has to establish the prejudice prong, and the prejudice prong is that he would have rejected the plea offer and gone to trial. So the motion
are you suggesting we can make that determination on this record, or that we have to send it back for a hearing?
I'm suggesting that the ruling can be reversed outright here at the appellate level, but at a minimum, it would have to be remanded for an evidentiary hearing before a motion for new trial could be allowed. But that doesn't even have to happen here. There's enough on the record here that you can just outright deny this motion for new trial, which would mean reversing the motion judge's allowance of the motion. So basically, there is no finding before you on the prejudice prong that's valid that you could affirm, because it was based on an affidavit from plea counsel speculating about what the defendant might have done. Right. So at a minimum, we can't affirm what the motion judge did here. So let's turn then to sort of the substance of the questions here. This material, does it qualify as newly discovered evidence? So at the motion hearing below in papers, we never contested the newly discovered component. This material would have met that definition, as it was unknown at the time and it was not knowable through reasonable diligence. So the newly discovered component, no problem. The second component, though, is that it's evidence. Inherent in the term evidence is that it's admissible at trial.
Well,
And
let me stop you right there, because I think Mr. Souza makes at least two arguments, and one gets into admissibility at trial, but the other is the notion that had this information been required or actually been disclosed, the defendant would have sought and pursued a motion to suppress and would not have taken the plea.
Well,
So
sure, Your Honor. So
that strikes me as an issue that needs to be resolved in terms of credibility determinations at a hearing. I don't think we can reject that outright, as you suggest.
well, that's fair, Your Honor, and that's for the court to determine. But were this to be remanded for an evidentiary hearing, then the defendant has to establish those factual predicates, has to establish the existence of actual admissible evidence, or that this material would have led him to some admissible evidence. And that's
So at a motion to suppress hearing, a judge would be forbidden from admitting evidence that the officer who allegedly spotted some evidence standing on a shelf had been convicted of a crime involving, let's say, credibility?
no, Your Honor, not at all. But that's not this case. You've changed the facts of this case. So at the time that the defendant pled guilty, Officer Smigelski was under federal investigation. He was not convicted. He was not convicted for another 6 months. And I point you to
I just want to make sure I have the chronology correct. He had conducted the activities underlying the federal indictment before this search.
Yes, Your Honor. Yes, Your Honor. The
All right,
questionable.
so the fact that he had a history of a certain kind of conduct in his official capacity, you don't think that would bear on his credibility at the motion to suppress hearing?
It can potentially, and we'll come to that I'll get to that momentarily. The first thing to be clear about is what we're dealing with here. The material that we're talking about is the existence of the investigation, not a conviction. And I'd point you to Hernandez for that point from the SJC in 2019. The newly discovered evidence are limited to things that existed at the time of trial. So at the time the defendant pled guilty, Detective Smigelski was under investigation. He wasn't criminally charged until 6 months later by information, and then pled guilty 2 or 3 weeks after that.
So standing corrected here, assume then that the information that was disclosed was that the key witness was under investigation for a crime involving his credibility. That would not be, again, a judge would abuse his or her discretion in allowing cross-examination on that issue at a motion to suppress that turns on credibility?
Potentially, Your Honor. So there.
Right, potentially. It's a discretionary call.
Yes, it is a discretionary call, but any discretionary call is reviewed for an abuse of that discretion. So let's turn to hear on what basis Judge Friesen indicated that it might have been admissible. First, so she decided it would have potentially been admissible as modus operandi under 404B. First, let's be clear that the legal test that she applied was not correct. She determined it was some sort of prima facie showing, not that it would have been admissible, right? And you can see that from the addendum at 53, where she said sufficient at this stage. That's not admissible. That's some sort of new standard that she's created. Now let's talk about.
Let's assume, I apologize for interrupting, but to cut to the chase, let's assume that Judge Friesen was incorrect in her reasoning, but that the information would be admissible on cross-examination for the purposes, in a motion to suppress for the reasons just stated. Assume that that's the case.
Okay, Your Honor. So now we're in the realm of the case that I sent the 16L letter on yesterday, in re grand jury, that the SJC just put out a few weeks ago, September 8th, I believe was the date. So generally under 608B, under Guide for Evidence section 608B, you cannot impeach a witness with specific instances of conduct, telling prior lies in the past. There's always been the one exception that we knew about in a rape case. If the contested issue was consent, you could go after the victim. You could impeach the victim with a prior false allegation of sexual assault. That's been around for a long time. In re grand jury on September 8th, Chief Justice Gantz sort of announced a newer possible exception to 608B for law enforcement officers. That's the realm we're talking about here. So there are a few things that the judge has to evaluate in determining if this form of impeachment will be permissible. First, it had to have been a key, law enforcement officer had to have been a key witness. Second, it had to have been a prior false statement. If you hit those 2 wickets, then there are 4 factors for the judge to evaluate. 1, age of the prior misconduct. 2, strength of the evidence of the prior misconduct. 3, simplicity of establishing the prior misconduct. And 4, is it probative of how the officer conducts investigations? So in Ray Grand Jury, the Chief Justice Gans pointed back to Lopes in 2018 and said that's where this springs from, which existed at the time of this hearing. Lopes' case existed. So that's the analysis that a judge would have to go through in determining if the defendant had made his substantial showing, basically, to even get to the evidentiary hearing.
And that was for, was that test done in the context of admissibility at trial?
Yes, the question is whether this would be admissible at trial. And that's what the defendant has to establish in the motion for a new trial.
Case was in the context of whether or not there was a Brady violation.
Yes, Your Honor, absolutely. The context of that case was about the disclosure of that information or not. But within the case itself, there is a section that deals with the admissibility of the material. They're evaluating the prejudice component of a potential discovery violation there. Within that prejudice component would this have been admissible at trial? So that's why we're looking at in Ray Grand Jury. The point is simply for the test that a judge can use to allow an exception to the general prohibition of impeaching a witness with a prior bad act. So here, if we go through those 4 factors, well, before we even get to the factors, first off, what Detective Smigelski did isn't even a prior false statement. It's certainly a breach of a duty. He disclosed confidential information, but it's not a lie. So there in and of itself,
It's arguably worse.
Well, okay, you could say that it's arguably worse. But what it is this test, this very narrow exception is 608B. It has to be a prior false statement. That's not what we have here. But assuming arguendo, you were going to determine that it was a prior false statement, then we go to the 4 factors. So the first is the age of the prior misconduct. Not in dispute. It happened 4 to 5 years before the guilty plea here, Detective Smigelski's misconduct. Second, the strength of the evidence of the prior misconduct. The criminal information doesn't state the source of the information, so we can't be sure, but I mean, the information issued, so there was at least probable cause to believe this. The third factor, the simplicity of establishing the prior misconduct. So here, these are the defendant's burdens to show this. I guess he would have to call in the 2 gang members as witnesses that Detective Smigelski disclosed the information to. And now we're talking about a trial within a trial here. And then fourth, is it probative of how the officer conducts investigations? It's not. Detective Smigelski's misconduct wasn't in an investigation he was participating in. He disclosed confidential information. He wasn't doing something improper in order to try to convict someone of a crime. He was trying to help a longtime friend out and notify him that he was under federal investigation. So it's actually the complete opposite on that factor. So respectfully here, if the judge were to weigh these 4 factors, they would find that this material would not have come in under the very narrow exception to 608B. So there's no way it could have qualified as newly discovered evidence because it was not admissible.
Thank you. I think let me see if there are any further questions for you. No? All right. Thank you very much for your argument. Attorney Souza.
Good morning to the panel. May it please the court, my name is Attorney Craig Souza. I represent the appellee, Timmy Hunt, in this matter. There are a number of issues brought up by the prosecutor, by the Commonwealth, in regard to whether or not the evidence discovered was newly discovered. The prosecution in the appellant brief is arguing that there is a basis to find that the evidence needs to be admissible in order for it to be considered newly discovered evidence. There are a number, I should say more precisely, there are 2 reasons against that, which was asserted not only by the court in relying on the Figueroa case, but also by the 16L case that was submitted by my brother to the court on the admissibility of this particular piece of evidence. The court in this case relied on Figueroa for the proposition that the evidence to be admissible or to be newly discovered we're focusing mainly on the prejudice prong, whether it should have been admissible at any trial. The import of that is the fact that in the Figueroa case, we were dealing with a trial. We're not dealing with a trial here, so the court correctly relied on the Figueroa case for the proposition that and cited to the language is whether or not it casts real doubt on the justice of the conviction. The evidence must not only be new and material and credible, but also must carry a measure of strength in support of the defendant's proposition. He relied upon that language in the event that we weren't considering a trial and what impact it would have had at trial on the jury. He's mainly considering whether he, in his discretion, when there is not a trial, may use that language in reliance upon that language to find in this case that the evidence was newly discovered. Whether it was admissible evidence to show the prejudice prong. The other import in this case I would like to argue is the fact that the judge correctly again relied upon the Rule 404B rules of evidence, where it's suggestive that this would have been admissible at any trial had there been a trial in the guise of whether or not we could use it as modus operandi evidence to suggest that that Detective Smigielski would have, in past cases where he had, in the past case for which the charges were brought up against him, would it have been would he have the same motivation, the motivation or the modus operandi to thwart a criminal investigation?
May I stop you here, because here I have trouble understanding what your theory is of the similarity between this case and the situation underlying the federal indictment. Is it your contention that, or suggestion, that the officer here planted the gun in the closet?
Well, it's a contention that if the investigation had not gone in Detective Smigielski's favor, that he had in all likelihood, had the ability, at least in the federal investigation, to thwart that investigation into the gang activity.
I'm not worried. Right now, I'm not asking you about the federal investigation. I'm trying to figure out, when you argue modus operandi, there has to be some similarity in the conduct in the two situations. So I'm trying to focus on just this search. Is it your contention? What is it that you contend that the officer did here that would be similar to what he did in the federal investigation?
Well, here we had a search warrant that was being executed by the police. It was known through the investigation that Detective Smigielski knew of the defendant in this case, the appellee in this case.
This occurred before the search warrant.
Correct. The place was frozen, the apartment was frozen, subject to the search warrant that later on issued. The search itself is what we're focusing on, at least what I'm focusing on, to make the parallel argument that there is this modus operandi.
But was there any, I don't understand. You're arguing that the suggestion is here that the officer conducted the search improperly?
I'm contending
when they were in the apartment pursuant to the arrest warrant.
Pursuant to the arrest warrant, well, I mean, the knock and announce, that all that, and it was ultimately frozen thereafter the search was made.
Right, but you're focusing on what happened before they froze the apartment, namely that the officer saw the gun in a box in the closet. What is it that you're saying the officer did wrong?
I don't necessarily I suggest that there would be more of an invest into his integrity, into his ability to thwart an investigation. I mean, this was a long, and I go back to the long known of this defendant as the basis of making that argument, where they would constantly searching for, and it was made, prior to the execution of the search warrant, the police were the defendant was well known to the police. They were after him for a long time. He was on the run for a
Sure,
long
but that doesn't seem to me to help your modus operandi argument at all, because in the federal situation, the officer acted to help the defendant, the target of the Fed's investigation.
Right.
And here, that's not what happened.
I think it's more of a general argument as to what he is capable of by viewing them together. We view an investigation in the federal case, thwarting that based upon, his own desire to be the lead investigator. In this case,
okay. So what are you?
It's mainly the impeachment of an investigation.
Excuse me. What are you suggesting that he did to thwart this investigation?
I would suggest that, given his character in a prior investigation, it will lead one to conclude that no other officer it was known that more than just one officer was in the room at one time, that you had a viewing of this box, and he was the only one that made that plain view observation saying.
So are you suggesting the gun wasn't there? That he planted,
obviously the gun was there in hindsight.
Okay, so you're not suggesting that he planted the gun?
No. What I'm suggesting is that whether or not it was a plain view observation of the handgun.
So you're suggesting he opened the box?
There was actually wording that there was a manipulation of the box. To the extent what that means in a general sense, we don't know. But what we can surmise from that, is if you're going back to the general premise of
where's the suggestion that the box was manipulated before the apartment was frozen? Where is that in the record?
The grand jury is impounded material, so I know we're live, so I
Okay,
don't really want to get into
it's in the grand jury. All right. We don't need to refer to the impounded material here.
It's not really modus operandi that you're suggesting is the value. It's just a pure impeachment of his credibility based on bad acts in the past.
Prior conduct. And where this case is specific, we do need to address the facts of this case. We would anyway, but as far as specifically, there are other officers present, and he was the only one to have viewed this. Present not only in the apartment, but present within the bedroom where the gun was located. Again, without getting into the grand jury, there's evidence there that there are other officers present. No one observed.
But the grand jury isn't relevant. Anything that happened in the grand jury isn't relevant to this motion.
Well, I would think that
you keep making references to the grand jury, but that we're limited to what the judge had on this motion is what we're looking at.
Correct. Well, I'm discussing the parallel between, or the argument that it's either we could argue modus operandi. We could also argue motivation. The motivation for this police officer when things don't go the way
we're taking this to. The question is, how is it admissible?
Well, it's admissible as impeachment evidence, and I think citing to the case that my brother cited to today, I think that the court unequivocally is saying that it's admissible as long as we find that those factors are satisfied. And I think even more so now in reviewing that case, I think we have, those four factors fall squarely, within the contours of this case where it would be.
But you'd agree that impeachment evidence, newly discovered impeachment evidence is generally not grounds to grant a new trial.
Right. It's not on its own. What we have more than that here, we have, we have the we have the affidavits of counsel to support exactly what happened during that time. And whether or not.
I apologize. Do you agree with Mr. McLean that there was no affidavit from your client?
There's no affidavit from my client. But
I
think it's a little more clear in my affidavit. It was a little bit more than suggestion of what I believe my client to have said to me.
I understand that, but how? Looking at the various issues that the judge discussed and that you raise, either this case comes down to either the defendant's credibility, number one, number two, perhaps the officer's credibility, and perhaps the admissibility of this information. How can any of that be resolved on an affidavit, and how can it be resolved without an affidavit from the defendant?
Well, I think that the case law.
Do you agree that credibility, I'm sorry to interrupt, but do you agree that credibility determinations are critical to this case?
Yes, but I also believe that we are dealing with a little bit more than just the typical instance where an affidavit is submitted in support of a motion. We have not only the affidavit of, and usually typically in those types of cases, we have the defendant filing a motion, his affidavit being the only affidavit that we're dealing with as far as the court having to make credibility determinations. In those instances where it's self-serving, you know, the court is likely, yes, we'd want to bring that defendant in order to make sure and cross-examination, as my brother suggested. But here it's different. Here what we have is counsel also submitting a detailed affidavit and confirming what the defendant had told me in regard to whether or not he would continue on with the case, whether or not he would have pled in the first place had he known of this information. That's all confirmed in precise detail in the 2-page affidavit that was submitted by defense counsel in this case. I think it's a little bit different.
I'd like to ask you a question so that I can understand what the practical consequences of your arguments might be. Assume we were to agree with you and we were to send this back down for an evidentiary hearing, or even assume we were to agree with you and affirm the decision of the judge, and then assume that there were a motion, your motion to suppress were heard, and that was denied.
Well, we would have had.
What are the practical ramifications?
The opportunity. Well,
what are the practical? You cut out for a while. What are the practical ramifications or consequences to your client from that?
If I'm correct in your example, you had suggested that the motion to suppress would have been denied. So if the motion to suppress was denied, it would go to trial. It would be, you know, based upon a jury determination of that evidence, whatever evidence. I mean, we're surmising as far, you know, the judge wouldn't. The judge is saying essentially that, you know, that the judge was also the same judge, which was the motion to suppress judge, who's also making the same findings. So we could take from that. I would suggest we could take from that it wouldn't have been denied, you know, had it gone on its face. But I see that my time is.
But I want to ask you a follow-up. Sure. Isn't there a potential here that your client's going to end up in a worse situation than he is now, having served the sentence that he received as a consequence of his pretty advantageous plea?
He had served a sentence, but ultimately, if there is a not guilty, I mean, we're talking a long-term implication on his criminal record. I mean, I think that carries a lot of weight with a lot of defendants, and you know what they do. You know, if he's released, for example, from prison, he would, you know, it's going to be a lot harder for him to do some things that.
But what the judge is suggesting isn't he facing some serious mandatory sentences on the underlying charges should the motion be suppressed?
And that's a decision to be made.
Not be suppressed. The suppression be denied.
We're talking the only Commonwealth witness that saw the object in plain view. I mean, the import and the strength of that evidence, and the likelihood of, you know.
Well, I mean, assuming if the motion is denied, then it goes to trial. The search warrant, we don't know who sees the weapon in the search warrant. I mean, somebody went back with the search warrant and it was retrieved. I don't know if it was the same officer or different officers that actually retrieved it. So, I mean, I don't, you know, the bottom line is, you agree that your client is potentially facing some serious mandatory sentences should the motion be denied.
Yes, I do. And having already served time, and that's a decision he would have to make. I mean, you know, would make at the time the new trial was granted. I mean, as far as how he
wouldn't that be part of a hearing on the prejudice aspect if the judge had actually gone to a hearing based on the affidavits. And in other words, the judge shouldn't have used the affidavits for anything other than determine if there should be a hearing, not for the merits of the hearing.
Well, I think that the specifics of what the affidavits included, again, I'm making that distinction between what we have in this case and typically in those types of cases where the court relies on the affidavit and the SJC is suggesting that, we shouldn't rely upon that. We have confirmation from defense counsel, which a lot of times in practice, you don't usually have that. You'll have counsel responding, but to remember in vivid detail exactly what happened and to provide the precise information that corroborated the decision of the defendant had he decided to go to trial, the decision, of having to, of going to trial, rather than
counsel
the implication.
Isn't that affidavit used purely for the judge's determination of whether there should be a hearing? That's the motion affidavit.
Yes, but I think it's a case-by-case determination. I think that's the whole reason I believe the SJC has said that it can be, decided on the affidavits without the grant of an evidentiary hearing, and that's the discretion of the court whether or not to grant one. And my argument is that there is the specificity of the affidavit, if you will, and not only the affidavit of a defendant coming forward saying that he will proceed to trial, had he known of this information, as opposed to the reasons for that described in detail legally, the legal ramifications.
Okay, I think we have your argument and we're going to have to leave it there. Are there any other questions? No. All right, thank you both very much for these very helpful arguments on this interesting case.
We are going live. And we are live.
Thank you both. Good morning. Welcome to the Appeals Court. It is my pleasure and privilege today to be sitting with Justices Neyman and Justices Lemire, and my name is Gabrielle Wolohojian. We are conducting today's hearing by Zoom in light of the ongoing pandemic, and we appreciate your cooperation and help in allowing us to conduct this hearing in this fashion. Just a reminder that you are both visible and audible at all times, unless of course you put yourself on mute, and that this argument is being recorded and simultaneously broadcast on YouTube, and also that the recording can be viewed in the future by anyone. So we observe the ordinary rules of argument, namely that there are 15 minutes per side with no rebuttal. And with that, I'm going to call the case, which is 2019 P 1612, Commonwealth versus Nazareth Perkins. And Mr. Weber, Attorney Weber, I believe we're hearing from you first.
Yes, thank you, Your Honor. Philip Weber, representing Mr. Nazareth Perkins. Mr. Perkins' case is here today as he was charged and ultimately convicted of committing an armed robbery. The armed robbery involves 3 individuals robbing a store, 2 of whom wore masks, and not the type of mask we're wearing today, but fully covering a face mask, and 1 who did not. Now, Mr. Perkins was alleged to have been one of the individuals wearing the mask. Now, there's no question that the robbery took place. That is undeniable. It's a fact. The question is whether Mr. Perkins was indeed that individual, one of the 2 individuals wearing the mask. And the evidence of that was not quite convincing. There was really a lot of the identification of him, a lot of the evidence against him was connecting him to one James Green. Now, James Green was one of the 3 individuals. He was the individual who wasn't wearing a mask. By the time Mr. Perkins gone to trial, Mr. Green had been arrested and he'd even pled guilty. So certainly no question regarding his guilt. Therefore, anything that would connect Mr. Perkins to Mr. Green was indeed quite significant. Thus, the 2 issues in this appeal.
Or to the robbery, right? I mean, anything that connected him to the robbery.
Yes.
And the defense at trial, I mean, at least in closing, really focused on the tattoo. It said the entire case turned on the tattoo.
Well, the tattoo was certainly a significant part of the trial. It was not the only part of the trial, but it certainly was a significant element of things. Trial counsel.
And the tattoo, you would agree the jury could conclude that the tattoo could conclude the defendant to the robbery, regardless of whether there was additional evidence that connected him to Mr. Green.
Then I would say maybe. Is it possible? Maybe it's possible. It's obviously, we aren't able to go inside of a juror's head, so we don't know.
Well, the video shows that one of the masked robbers has a tattoo on his, I think, right hand, and the defendant has the same, or at least one could conclude the same tattoo on his right hand.
The defendant's tattoo is similar. One of the things trial counsel did focus on in closing were the differences, which, although subtle, are indeed, when you're talking about a tattoo, subtle differences are significant. And I won't belabor the point in going through the details. Your honors have access to that closing argument, so your honors have the ability to read through the differences. Another thing that trial counsel pointed out throughout the case is that this is not the most unique tattoo in the world, actually. In the Boston police database alone, there were about 50 to 100 individuals who had a similar Adidas tattoo, and about 5 of those people had it on the right hand. And this is just the Boston police database. So we're not talking about every person out there who could possibly have this tattoo, just the ones who've been logged into the Boston police database. And already you have 50 to 100 people, and then 5 of whom on the right hand. And that's the Boston database, not even the Massachusetts one. So, certainly could be an individual from outside of Boston. So I would say that the tattoo alone is a fairly generic tattoo. And I'm not saying that it is nothing, but I don't think it is definitive on its own. And I think without connecting Mr. Perkins to Mr. Green, there is indeed a very real question as to whether or not the jury would have found him guilty. So while maybe...
Wasn't there additional information about his height and build that was connected to the tattoo from the Boston police records as well? And I believe, didn't he also reside across the street from the market? So there was more that tied him in with the tattoo, such as his height and his build and his residence, without even referring to the phone calls.
Well, his height is 6 feet. We're not talking, 6 feet tall, which is, he's not 5'1", he's not 6'10". This is not a rare height for a person to be. There are a lot of people out there.
No, but it's the same height as the robber.
Yes, but at least the height that you could see from the video seems to be 6 feet. But the point being that 6 feet tall is not a rare height for a person to be. So for him to have a similar height is certainly not definitive. And even the build is essentially that he's a large man, and he is a large man, but someone being 6 feet tall, being a large man, those two things are, I would argue, certainly not definitive, certainly not enough.
But you would agree that you don't look at each piece individually without reference to the other pieces of evidence, but in the totality. So we have a person, the video shows a 6 foot tall person who's large built, with a particular tattoo on his right hand. And the defendant is a 6 foot tall man with a large belt with the same tattoo on his right hand, who also happens to live across the street.
Well, the living across the street part, I don't actually think really should mean much of anything. He happened
But aren't these all questions for the jury to just decide?
These are questions the jury decide, but I think the problem here is that we don't know what the jury would have decided had it not been for the evidence admitted that should not have been. Could the jury have possibly have found him guilty without the evidence linking him to Mr. Green? If the question is if it's possible, yes, it is possible. Would it have happened? I think that is much more speculative and less likely. I think these things connecting him are, I suppose in any case, it is possible when we look at the evidence, but I don't think it is as likely. I think that even when you consider these things together, he is someone of a fairly average height with a fairly generic tattoo. Even all these things together are just little bits and pieces that these inferences added together, I don't believe reach the level that we can say he would have been found guilty had it not been for this inadmissible evidence.
Can you turn to your argument on the authentication of the cell phone records? I have to admit that I'm a little bit puzzled by the argument. You're not saying that the phone company's records were not authentic business records, are you?
No, that is not.
That's not your authentication argument. Instead, you're arguing, I guess, that there's no evidence to suggest that the defendant was the person who used, and you're not saying that, and your authentication argument doesn't go to the fact that the defendant was the owner of the phone.
At least was subscribed to him.
Subscriber, okay,
Connected to
at his address. That's
that much is correct.
You don't contest that. As I understand it, what you're contesting is, in the sense of authentication, is the idea that the defendant himself was the person who placed the calls to Green's phone.
That is correct, Your Honor, in regards to the authentication.
Okay. Did anyone argue at trial that the defendant was the person who made the calls?
Well,
or did they argue that the calls, all those calls were made from his phone?
Well, I don't remember the exact wording that the Commonwealth used. It's quite clear that they were arguing that he was the one making those calls. I mean, their argument throughout the trial was that Mr. Perkins was calling Mr. Green on the day of don't recall the exact number of times, but however many times. That certainly was the Commonwealth's argument. They weren't just arguing that his phone was randomly dialing Mr. Green's. They were arguing that Mr. Perkins was calling Mr. Green. Without that, evidence doesn't really hold the sway that the Commonwealth would have wanted it to.
But aren't the authentication cases, don't they deal with the content of either a text or an email or something that is a written or oral message, as compared to the records showing from the phone company that calls were made on a certain date between this number and that number without any context or content of the conversation? Do you agree there's a difference between just showing mechanical calling that the phone company keeps track of as compared to an actual message that had to be authenticated?
There are some distinctions to be made there, but ultimately, when all is said and done, I believe that the important thing is the communication between the two. So while many cases are addressing the content, regardless, I believe the authentication issue still holds true here, because at the end of the day, if we can't say that it was Mr. Perkins who made these calls, if we can't authenticate that the calls were made by Mr. Perkins, then I don't believe that evidence should have come in. What's
your best case for that?
I apologize that I don't have, I don't know if there's one specific case, because I will admit to your honors that most of these cases do address content, because that is oftentimes the most argued point of these things, but I don't believe that means that the actual calls back and forth aren't as relevant. It's possible this could be slightly new territory in that regard, but nonetheless still relevant and significant to this case and in general.
Well, that sort of begs the question, which is this really an authentication case? The business records, which you agree the foundation was established for them, show and authenticate that calls were made from subscriber Naz to subscriber June and from subscriber June to subscriber Naz. We don't know who was actually on those calls, but and that's your objection. You're saying, well, there's not enough proof that the defendant made those calls to his co-defendant and vice versa. That doesn't really strike me as an authentication. It strikes me as a 403 relevance test. And I think what you're really arguing is that the risk of prejudice substantially outweighs any probative value without corroborative evidence. And I think corroborative evidence is obviously akin to confirming circumstances, but it strikes me as a slightly different test. And so can you tell me, am I incorrect in my analysis?
Not quite. I think there's, I mean, Your Honor certainly has a point. I think if the evidence had been admitted with a limiting instruction, if it had been given the instruction to a jury informing them that this is just evidence that the phone had called the other phone, not as much that Mr. Perkins had made it, then I think it would have been framed more within that relevance issue. But since it wasn't admitted with that type of limiting instruction, I think it does very much go to this authentication issue. I don't believe the jury would have, at least on their own.
The judge asked those very questions at trial, and I'm on trial transcript volume 6, page 24. They were cross-examining Mr. Witt, who was the expert, and the court said, let me clarify something on cross. And she said, Mr. Witt, when you refer to the subscriber, you actually meaning the subscriber's phone? He basically said yes. And she said, but we generally don't, unless we see it, we don't know who is using the phone. The witness said, correct. It's just who has the responsibility for paying the bill. So you're referring to the subscriber's phone when you say subscriber. Yes. So the judge in her questions clarified the very issue you're raising here. She said all this, her questions elicited the response that it were essentially, all this information shows is that calls were made from one phone to another, not who made the calls. So why does that not get us there?
I believe that it's so, I think I believe the significance of whether or not Mr. Perkins made the call, it goes to such a great length that, because the prejudicial and probative value, as Your Honor pointed out, certainly is a factor that obviously needs to be considered in regards to everything. So when Your Honor brings up the prejudicial probative value in regards to relevance, it is, well, as Your Honor yourself said, it is akin. There certainly are overlapping issues in that regard. But I think ultimately, without the authentication of knowing that it was Mr. Perkins who made the call, that authentication in general, I believe, should be required before these it could be able to come in. Because
I also have to say that similar to Justice Neyman, I have a question about whether you are really correctly challenging authenticity, as opposed to whether it's relevance or some variation of an argument that it's just too speculative to conclude from the fact that calls were made that who was the person or the persons who were on those calls. I think, to me, that sounds more like what you're saying, that without that you can't make a reasonable inference from the fact that the calls were made on two subscribers' phones as to who was making the calls.
Well, as the issue had been framed during the trial in regards to authentication, that is a strong reason as why I was focusing upon the authentication, as that is what was argued by trial counsel. That was the issue addressed by the trial court. And that certainly is, as that was the issue being addressed by the trial court, was a large reason why it was addressed in that regard. I see my time is finished, so unless Your Honors wish me to continue,
I don't see any. Thank you very much for your helpful argument.
Thank you, Your Honor. Honors.
Attorney O'Sullivan.
Good morning, and may it please the court, Shane O'Sullivan for the Commonwealth. The cellular telephone records in this case, which did not contain the content of any messages, were properly authenticated as business records. The keeper of the records clearly established the foundational elements necessary for authentication in this case, and the evidence contained within those cell phone records was probative of the defendant's identity, both as the owner and subscriber of that phone, but also as the perpetrator and the potential person making many of the calls listed in those records, predominantly the ones geared towards Mr. Green, and the calls geared towards Mr. Green in the time just prior to the robbery. I think, as Your Honors have alluded to in my brother's argument, I would frame this somewhat differently. I think the authentication is clearly established. There may be
is a better question or a closer question regarding relevance, but the judge has broad discretion in this area, and there certainly was evidence from which the trial judge could draw to conclude that this evidence was probative. Most important on that fact, in my eye, is the principle that evidence, although colorless on its own, can gain complexion from other facts. And the 403 balancing test, and considering whether evidence is probative, really hinges on a view of all of the evidence viewed in its totality. And in this case, there was a wide variety of evidence pointing to the defendant as the perpetrator. I wouldn't go so far as to say that the phone records were a sideshow to the main issue, but they were what I would say was a small component of the evidence the Commonwealth presented to show the identity of the perpetrator as this defendant. Of course, if all the Commonwealth had were records that showed this 7-digit phone number contacting Mr. Green's phone, that would not be probative of anything. But with the subscriber information listing the defendant's name and address, the quantity and timing of the communications, that they were in frequent contact leading up to the robbery, that the phone somehow knew not to contact each other within the half hour leading up to the robbery and the time during the robbery, that both phones didn't engage in any communications during the time of the robbery except for one missed phone call. Most importantly, I would say the matching tattoo, which the Commonwealth would characterize as quite specific. The Boston Police database only had 5 of these on that same hand. And that database, although it was only the Boston Police database, I think there's nothing to suggest that it was only Boston residents that were in there. It was an arrest database. And it was a database that was compiled over a number of years. This was a wide-ranging search that was done. The defendant's matching height and build to the perpetrator and the approach of the perpetrators from the area of the defendant's home and their familiarity with the store. The Commonwealth would more properly characterize the defendant's arguments as going to the weight of these phone records, which I think is the argument that defense counsel made in the trial. And that's how I would characterize them as properly being conveyed to the jury as a matter of weight, which the jury perhaps rejected. In regard to the recorded jail call admitted to show Mr. Green's state of mind, the trial judge ruled.
Let me ask you a more pointed question. This was potentially double hearsay. Could you identify the 2 layers of hearsay and identify the 2 exceptions or reasons why each was admissible, please?
Sure. I think from the outset, we have the defendant's alleged statement, tell Mr. Green, I said, what's up. So if we assume that had come from the defendant, then that's an admission of a party opponent, right? The then next statement of the unidentified female on the phone call and Mr. Green, the Commonwealth argued was relevant to show that the parties potentially knew each other. The trial judge characterized it as relevant to the state of mind of Mr. Green. I think it's maybe more properly characterized as a statement relevant for Mr. Green's knowledge. And I point out in the brief that even if the unidentified female's statement didn't fall within an exception, it is necessary to give context to Mr. Green's statement. And this exception I think is more commonly seen in police interrogations or 911 calls where the 911 operator or the police interrogator doesn't have any, hearsay exception, but because it gives context to either the spontaneous utterance in the context of a 911 call or the defendant's admission in the context of a police interrogation, those statements still come in. If
Could it qualify?
Mr. Green,
Could it qualify as a statement of identification?
I suppose it could qualify as a statement of identification, but the reason that it was asked to be admitted and the purpose it was used for was to show Mr. Green's knowledge. I do believe it was relevant that Mr. Green knew the defendant, that they were apparently familiar with each other, given that the Commonwealth was alleging that they were co-venturers in this case. And given that this was a crime that the Commonwealth argued, and I think the facts conclusively showed, clearly involved some level of planning, right? The perpetrators entered together. Two of them were masked. Two of them were armed. They were seemed to be somewhat disciplined and methodical in the way that they went about carrying out the robbery, going immediately to the cigarette case, which is an item of value behind the, they clearly had displayed some familiarity with the way that they were able to so decisively go to the areas within the store that they went to, and then leaving through a door that was not often used and having a getaway car pull up in that interim and be able to escape within a very short period of time. So that these individuals were known to each other, and then going back to the phone records, that there was seemed to be a lot of communication in the time leading up. Just, I think, corroborated the Commonwealth's case that the defendant was one of those involved. So the knowledge, what would the judge refer to as state of mind, what I'm going to refer to as knowledge exception was, I think, the relevant exception in the way that it was used. But Mr. Green's statement was relevant for that purpose. It was not admitted for its truth. No one, alleged or really cared whether Mr. Green on that particular day was sending a salutation to the defendant. What mattered was that he acknowledged his identity and knew who he was and responded to the Naz says what's up without being puzzled or confused in any way, that this was clearly a person that was known to him. So for that reason, I believe it was properly admitted. The judge was within their discretion there. If there are any further questions from the panel, I'm happy to answer. Otherwise, I would rest on the brief.
I don't see any. Thank you for your argument. Thank you both. It's an interesting case. We appreciate your help in arguing it. And
5.
thank you. Good morning, everyone, and welcome to the Zoom argument of the Appeals Court. It is my privilege to be sitting today, and your privilege to have as your panel Justice Neyman and Justice Lemire, and my name is Gabrielle Wolohojian. We are conducting today's hearing by Zoom in light of the ongoing pandemic, and we appreciate your help in helping to make that happen. But I'd like you to be aware that you will be on screen and also be able to be heard while this recording is going on, so you might want to keep that in mind. This is being simultaneously broadcast on a YouTube channel where it may be viewed by anyone, and it will also be stored and available for viewing in the future. With that, I'll also mention that even though it's on Zoom, we observe all the ordinary rules of argument, which include that each side is limited to 15 minutes and there is no rebuttal. With that, I'm going to call the case. It's 2019 P0974, Thomas F. Patch versus Town of Hingham. And Attorney Patch, we're ready whenever you are.
Good morning. May it please the court. I am Attorney Thomas F. Patch, plaintiff appellant pro se in this matter. The matter before you is my appeal of the Superior Court's allowance of the appellee's summary judgment motion. Also, there was no action on my first motion to strike directed at the appellee's summary judgment motion. There was a denial of my second motion to strike directed at their reply to my summary judgment opposition, and denial of my motion for reconsideration of those matters. I commenced the action seeking declaratory and injunctive relief to challenge the validity of the appellee's pre-commitment to the tax collector's purported betterment assessment in the amount of $18,837 with interest tacked on to that. This betterment assessment was determined by and imposed by the appellees as an involuntary encumbrance against my real property interest of 9 Ship Street, Hingham, Mass. The appellee's action was purportedly pursuant to a statutory authority authorizing betterment assessments to recoup the cost of construction of a public sewer, and I emphasize public sewer, in addition to the construction of the sewer itself. I'm here to ask the court to reverse the summary judgment entered against me by the Superior Court, and further, under Rule 56C, to order entry of summary judgment in my favor because it is appropriate, or if the court decides that it's not appropriate, then to remand the matter for trial. The gist of my challenge sorry.
I'm sorry to interrupt you. Is your contention that this was not a public sewer?
No, Your Honor. What it is that the statutory authority under which the appellees acted to construct the sewer as well as to impose the sewer betterments was for the construction of a public sewer. So if you look at the special legislation involved, as well as the analog chapter under the general laws, which is chapter 83, the authority is to construct a public sewer. And there's a difference because there is authority, separate authority, for the municipality to appropriate money and to construct essentially the private connection to the public sewer. So you have, in any kind of sewer situation, Your Honor, you have two scenarios. You have the public sewer, which is owned by the municipality and operated by the municipality. Then you have the private sewer connection infrastructure from individual properties to the public sewer. So the authority under which they acted to construct the sewer, as well as to impose the betterment assessments, was limited to the cost of a public sewer.
So but not a public sewer. I'm confused by your terminology, I think.
Okay.
You're not contesting that this was a public sewer. You're contesting whether all of the charges they included were part of the public part of it. Is that correct?
I am, yes, Your Honor. But yes, I do not contest that.
And is that because of these pumps that were associated with individual property owners?
Yes, Your Honor. There are several issues here. So in terms of ineligible costs, so you have the clearest example is the grinder pumps. It is an undisputed fact that these grinder pumps were not acquired to be part of the public sewer system. They were acquired to be effectively given for $1 to certain properties that abutted the newly constructed public sewer system to use in their connection, their private connection to the public sewer. So they're not part of the public sewer. They're part of your private connection. And both the special legislation and the analog general laws under Chapter 83 provides for the authority of the town, the municipality, to appropriate money and construct the private connection infrastructure to the public sewer. But the condition of that is that the municipality can only assess that property for that cost. So my contention here is what they did is they acquired these grinder pumps for a little over $21,000. There were 5 of them. They consummated their deal with 2 of the 5 property owners who purchased them for $1. The other 3 remain unaccounted for but the sewer system was already, public sewer was already completed and up and running at the time they acquired these. There's no evidence that these 3 other pumps have been incorporated into the public sewer system itself. And what happened was they then took the entire amount, the approximately $21,000, and they added it into their total cost amount when they figured out the betterment assessment. The problem with that is not only did they add an ineligible unlawful cost because it wasn't for the construction of the public sewer, but a private connection. What they did is they voted to assess 100% of what they claimed was the total cost of the public sewer system as part of these betterments. By, in effect, having an ineligible cost included in there, they, in effect, exceeded that cap. So by way of example, if they said their total cost was $100,000 and they were assessing 100% of that, but it turns out $10,000 of that was ineligible, then what they did was they exceeded their authority to assess cost for the betterment, which would have been limited to the $90,000 in that example.
In your view, the 100% of the cost provision relates not to the system as a whole, but just to the particular expansion on this occasion?
Yes, Your Honor.
Where does that, where do you derive that position from?
Well, it's in the language of the language of the special legislation and the analog general laws, and even the document.
Can you tell me where?
It would be in chapter Acts 1946, chapter 82. I believe it's section 8. It's the authority to impose betterments for the cost.
What about in the general laws?
The analog provision, well, they didn't act pursuant to the general laws necessarily in terms of doing that, but I just offer that there's an analog general laws provision. In the general laws provision, I believe it's section 20, I believe it's section 27. The issue, I just would like to make a point. There's a separate issue about whether or not the special legislation at one point was amended to deal with the requirement of the town's share. The town meeting was required to vote, and they did a vote in 1955, the town's share of constructing the public sewer pursuant to the special legislation in the whole of the district. And the town voted to pay 65% of it, and therefore 35% would be bettered out. That special legislation was subsequently amended to apply to the whole of the cost of their 65% obligation was applicable to construction of the whole of the cost of the district. As to any particular construction, they cannot statutorily exceed the cost of the lawful cost of that particular construction in bettering out the sewer. And so what they were doing was they were effectively, over the last 50 years, they've been doing this in segments. So every time they would do a segment, they would, go through this betterment process and make a determination, and you cannot assess out to the properties to be lawfully required to be assessed more than the cost of the specific project at hand. That's just fundamental betterment law in this situation. So my position is it's indisputable fact that they included this ineligible cost in their total amount, and therefore it voids the betterment. Now, I say it's indisputable because
it voids it because it exceeds 100%.
It voids it because A, it's an ineligible cost, and they have no authority to do that. And where they assessed out, the town didn't pay any share of this. The town might have an argument had the town paid some share of the construction cost. For example, under that scenario, gave you the $100,000 with the $10,000 in the ineligible cost. If the town had paid $10,000 towards the cost of the construction project, the town could probably make an argument. I'm not necessarily saying I would buy it, but the town could make an argument that, well, fine, we had $10,000 in ineligible costs, but our $10,000 share goes towards that. So at the end of the day, we're only assessing you $90,000, which is the maximum legal eligible cost that we can assess to people under the betterment law. So and then you have there are other instances which I submit they're at least a triable issue of whether or not they constitute ineligible costs. And that would be, there's attorney's fees that were included, and opposing counsel redacted the attorney's fees bill to exclude the information necessary to determine whether or not they actually related to this particular sewer construction project. And as I pointed out, I believe I raised the issue in my brief, and I more specifically addressed in my reply brief under the rules, mass guided evidence, when you essentially take a position of redaction based on privilege, which was my understanding what was happening here, an adverse inference can be drawn even if it's an attorney-client privilege. So an adverse inference could be, I'd be entitled to that for purposes of, the fact finder saying, well, it would therefore seem that some or all of these costs, legal costs that are being included in this total cost amount that's being bettered out, were not eligible costs because they might be for some other aspect of the sewer, not this particular project. And then there's another instance of there was some wages to apparently a sewer department employee that I simply pointed out, if you look at these timesheets, they're referring to other locations other than, they refer to this project, the Ship Street, Cottage Street construction, sewer construction, but they also referred to apparently work that was done at other areas in the district. This sewer was not connected until subsequent to when those wages were done. So the fact that there was apparently the employee was going to different areas in the sewer district and doing what apparently is station checks, and I did cite in my reply brief, I pointed out the minutes of the sewer commission meeting where this issue apparently came up. He was doing station checks of other areas in the sewer district, but it was billed off to this project. And again, what the town did is by deciding to 100% better the cost of what they claim was the total cost, they put themselves in a predicament, Your Honor. They left themselves no room for error in the event that any part of those costs were deemed ineligible. And once you do that, you're voiding the whole of the betterment. Again, because this
What is your authority for the idea that the entire betterment is voided if some costs are incorrectly included, as opposed to, for example, a trial on whether or not certain costs were inappropriately included, and then a reduction in the amount of the betterment for each person who was subject to the betterment? Why does it void it?
Okay. Well,
what is the legal authority for that notion that it voids it?
Because
I'm looking for a citation.
Okay, under their statutory authority that they exercise, the special legislation, their authority was limited to the cost of this particular public sewer segment. So if they...
But why would it void it as opposed to reducing pro rata the amount of everyone's assessment?
Okay. Well, first of all,
does it say anything in the statute about voiding?
No, it doesn't. However, Your Honor, if you this challenge was pre-commitment to the tax collector, and that is, if you look at the case law that I've cited, those are instances where you're not limited to, you're not addressing this abatement scenario that you're talking about. There's an alternative relief of the abatement scenario, but that's post commitment to tax collector. So we're not dealing with that instance in this case. And in those cases where in those cases where it's a pre-commitment tax to the tax collector challenge, the courts have declared, and I cite some of the cases that even counsel, the town special real estate counsel cited, that the court declared that the betterment was void. And that's because they exceeded their authority.
I have one other question for you.
Yes, Your Honor.
And that is, can you identify for me, and here I'm looking for the names of the streets
Yes.
that you claim were private ways?
Okay. They are unnamed private ways. To be a private way, you don't necessarily have to have any kind of name. Okay. So there's a private way from Ship Street that runs towards from Ship Street, and it runs easterly towards number 15 Ship Street and 11 Ship Street, which are in the rear of and they have this right of way. And I provided all the title information to show that they have an easement right, and under 187 section 5.
Right, an easement is not necessarily a private way.
I understand that, but the point is it's used as this private way, okay?
Will we see anything in the record that identifies it like as a private way on a map?
Okay, what you have is you have on plans and in deeds referring to as a right of way.
Okay, so the answer to my question is no.
No, the answer.
We will not see anything that specifically identifies either of these as private ways.
The word private is not used. The word private is to the status, the legal status of this way. If it's not public, it is therefore private. And that's just the way it works with ways. So, and in both of these instances, there are plans referring to these as rights of way on private, they're on private property. It's not public property. Therefore, it is a private way.
Okay, I understand your argument and your time has expired. So we're gonna have to leave it there. Attorney Ryan?
Thank you, Your Honor. May it please the court. My name is Kerry Ryan and I represent the town of Hingham and the town of Hingham Sewer Commission. What I'd like to do first is just point out one procedural issue. Last night I received about 8 e-file notices of something being filed in this case last night by the plaintiff. It appears that it was some sort of amended record. The document was 508 pages long and appeared to be the same as the prior document that was filed. I have no idea what was filed last night, but I got 8 notices of it, and I'd just like to note that I object to something being filed last night for purposes of today's argument and for purposes of the case. Jumping to the merits, Your Honor. I think that one of the things that the plaintiff has pointed out is this idea of pre-commitment, that he filed this suit, and he specifically said, I even cited cases that, the town has used. The plaintiff has referenced 3 different cases that apparently get him in the door to be here today. And those are in the record at volume 1, page 497. Those 3 cases, from what I can tell, all pretty much have one thing in common, which is they all relate to the idea that the town may not have done the notice provisions correct on the assessment or applying the betterment. In other words, the lien was filed late or something along those lines. I'm not aware of any case that talks about an appellant being able, or a plaintiff being able to come in and start questioning each various charges and then trying to say, well, if it's $1 off, the whole thing's a void, or anything along those lines. I'm not aware of any appellate case. The appellate cases that allowed the plaintiff in the door appear to relate more to timing of the liens and things. The second choice plaintiff would have had is to file an abatement action, completely different action. And he actually did that in this case and then voluntarily dismissed that case. So that case was pending and was dismissed. So what your honors have in front of you is a case where, at least from the town's point of view, we would argue that he does not have standing to make many of the arguments that he has. One of the key components of standing, of course, is that there be injuries. And those, need to be above the speculative, remote, or indirect, or the courts have been pretty clear that those are insufficient. It has to be a legally cognizable injury. And we've cited the various cases.
Well, if his assessment is too high because there were certain expenses included in the assessment that should not have been included, why would that not be a cognizable injury?
I believe if he could prove that there was specific and something beyond de minimis, yes, he would be able to come into court. But that isn't what has happened here.
Well, why isn't that a factual question?
I believe it is
hard to resolve on summary judgment.
I'm sorry, Your Honor, I did not mean to cut you off.
No, it's hard because there's a delay. Don't worry.
I'm sorry. Well, Your Honor, it would be a factual matter if he was able to present any proof of that such that it would not be an undisputed fact. In this case, the town submitted undisputed facts that the court agreed with. I'll go to the one that the plaintiff led with, which was the grinder pumps. And I think that's a fairly simple one to deal with. The plaintiff alleges, well, the grinder pumps aren't part of the sewer system. He ignores what is part of the sewer system. The DEP permit is in the record at volume 2, page 52. In the DEP permit, and again, volume 2, page 63, the DEP permit specifically includes the grinder pumps. So for the plaintiff to stand there and say, grinder pumps are not part of this system makes no sense. The whole purpose of a grinder pump, as described at the trial court, is because the sewer system basically operates primarily on gravity. And so if there's a portion of the layout that in order to make the gravity, you have to dig a bigger trench, it can become very expensive, especially if there's ledge or something along those lines.
So is your argument that because it's included in the DEP permit, as a matter of law, the grinder pumps were part of the public project as opposed to being a privately, part of the private connection? Or is it that it's a question of fact?
Your Honor, I guess I would say that there were a couple arguments with grinder pumps. One of them was that it's part of the DEP permit, which addresses, is it part of the system or not? Second, is the grinder pumps reduce the cost of the system? So I don't know how the plaintiff has any standing to argue about a cost that reduced the cost. You have a choice. You either dig a deeper trench and blast ledge, or you put in grinder pumps, a significantly less cost. In this case,
it was a significantly less cost, but I think his argument is that you incurred the cost and you chose not to shift that cost to the individual property owners, and that increased the cost of the general project.
I'm not sure how you could shift it to the individual property owners. I think if you were to go down that road, what you would be saying is, well, if you happen to live on the hill where the sewer is put in, you have to pay more for your sewer than the person that lives next door that's slightly down the hill. I'm not sure how the town could get into that kind of line drawing. The permit was issued with the grinder pumps being part of the permit. They were done to lower the cost of the project. And that's why I go back to standing, Your Honor. There has to be an appreciable damage to the plaintiff. It lowered the cost. How can he be damaged if the project component here, it's just as if he said, well, I'm disagreeing with the fact you used a U in the way that you built the pipe, and that you should have used a straight piece instead of a U piece part of the pipe because it's more expensive. Well, that makes no sense. We have a system, it was approved by the DEP, and it reduced the cost to do it the way we did. And so that's where—
Can you address the issue of the 100% of the cost? Assume for the moment that the 100%, would you assume for the moment that the 100% refers to the cost of this particular extension of the town's system. These
You are
29,
correct.
these 29 houses. It's not 100% of the entire system, but it's of this particular betterment.
Correct, Your Honor. In fact, what the plaintiff is missing is under the Acts of 1955, Chapter 454, Section 2. The statute in particular says the town shall not, it's all calculated on the entire cost of the North Street Sewer District. The affidavits that were submitted, including the affidavit of Gene Montgomery, pointed out that the sewer district, that sewer has not been completed. This small portion of it was 100%. Based upon the entire thing, the town currently has paid, I believe it was approximately 71% of the sewer cost.
But is the town taking the position that it was limited to assessing 100% of this component, these 29 houses, and that it didn't exceed, and that the assessment did not exceed the 100% of that cost?
Correct, it did not exceed.
Okay, the town is not relying on 100% of the whole North Street system, right?
In order to come with the percentages, you need to rely on the whole North Street system. And that's how the treasurer is obligated to, under that statute that I cited, the Chapter 454, Section 2, that's how the treasurer has to determine the percentage. And so this particular segment is 100%. And to look at the percentages, you have to look at the entire system that is constructed.
What do you mean this segment is 100%? What is it 100%?
This is only a portion of, I'm sorry, go ahead.
Right. I'm worried that we're talking at cross purposes. The assessment on the plaintiff's property and the other 28 people, that was 100% of this segment?
Yes, Your Honor. Because they were the ones that were bettered. They were the bettered of the people that were actually hooked up to that portion of the system.
So then why do we care that what the percentage, how much of a percentage of the entire system, the entire North Street system, this segment constitutes?
That just simply sets the requirements, Your Honor, for what the town is allowed to charge. And so they're allowed to charge up to those percentages.
But they would never be allowed to impose on the people subject to this component of it, more than the cost of this component. Is that correct?
Correct, absolutely. And there was quite a bit of evidence that was submitted at the trial court that was not disputed as to the specifics of which components were in it. For example, one of the other items that was objected to was the extension into the private ways. Your Honor, you previously discussed that. And there was no issue of private ways. The homes that were connected to the sewer were on the same street. This is the Ship and Cottage Street sewer portion of the segment. The homes that were connected were on Ship and Cottage Street. They happened to be landlocked, and so there was an easement that was given to the town in order to bring the sewer into them. There was no private way issue. And so I understand counsel has argued that several times, but there were easements that were issued. Those easements were submitted to the trial court, and the easements themselves, there was no dispute on those. One of the other...
I have a question for you just about the relationship between the special legislation, the various pieces of special legislation, and the general laws. If there's some tension between them, what happens?
Well, I guess, Your Honor, one of the primary general laws that applies in this circumstance is Chapter 83, Section 15. That chapter specifically allows the unit pricing that was done by the town. What the plaintiff has pointed out in his brief is there's a conflict. between the old statute from 1946 and the new statute. First, there were two conflicts. Number one was that you couldn't do unit pricing under the original statute. Then that was amended by the general law with the Chapter 83, and the W.R. Grace case that I cited dealt with that and reconfirmed that yes, the municipality can do that. The second conflict that council has pointed out is with regard to whether or not you go to the Department of Public Health or you go to the DEP. And in that, Your Honor, I think is very clear of where you end up. And that is, as was submitted at the trial court in, I believe it was 1966, there was a change. Yes, it's 1966, the acts, and it's chapter 685, in particular, section 3. Everywhere where it referenced the Department of Public Health in statutes was turned to at that time, they called it the Division of Water Pollution Control, which was a portion of the DEQE, which eventually became the DEP. In fact, the permit has that Division of Water Pollution Control at the top of the permit. So that's the other conflict. And what council has argued is, well, you didn't do the hearing at the Department of Public Health that you were supposed to do. But the regulations or the permit that was issued by the DEP was even copied to the plaintiff, to Mr. Patch. That permit is in the record at volume 2, page 52. And you'll see on page 53, volume 2, that permit was both copied to the plaintiff and he had the opportunity to appeal from that permit. So if indeed the plaintiff argued that he didn't get his public hearing, he should have appealed that permit to the DEP as he was given notice of it. And that was back in August 21st, 2013. I would say, Your Honor, that he has no standing to file suit against the plaintiff or against the town of Hingham, I'm sorry, for failure of the Department of Environmental Protection to hold a public hearing. The DEP's the permit makes clear that they did put it out for public comment. They did receive public comments. They responded to the public comments and included an appeal provision in the permit that was issued that was specifically sent to the plaintiff, none of which he did. I'm sorry, I see my time has expired, Your Honor.
Let me see.
One very brief question. I saw your citation of the acts of 1966, chapter 685. Nowhere in that does it say that DPH no longer plays this role. So I guess your argument is that, at least by implication, and I saw the affidavit that said as a practical matter, that's what has happened. But the statute itself does not speak to DPH no longer having a role, correct?
Well, you're right, Your Honor, in that the letter from the General Counsel of DPH made it clear that no, we no longer have a role. I would point out, though, in the 1966 Act, Section 3, which is on the last page of that act, which is kind of a little odd because there are prior sections with higher numbers. But Section 3 talks about the employees of the Department of Public Health may at their request transfer to the Division of Water Pollution Control. I would say, Your Honor, that certainly implies that the Department of Public Health would no longer have activity with regard to this particular item that is now going to be handled by this separate agency. Anything else, Your Honor?
I don't see
Thank you very
anything.
much.
Thank you both. It's an interesting case at all times while the argument is going on. The argument is being live streamed on YouTube as we're conducting it and can be observed by members of the public. And it will be stored and available for viewing in the future as well. Although we're conducting the argument by Zoom, the ordinary rules of the courtroom apply, which means that each side has 15 minutes to argue with no rebuttal. And with that, I'm going to call the case, which is 2019 P 1500, Ari Soroken versus Falmouth Conservation Commission. And Attorney Wall, we're ready whenever you are.
Thank you, Your Honor, and may it please the court. My name is Brian Wall, and I represent the plaintiff appellant in this matter, Ari Soroken, trustee of the AMS Realty Trust. As I'm sure the court is aware, this is an appeal of a decision by the Falmouth Conservation Commission denying Mr. Soroken's proposal to construct an elevated wooden walkway to provide access from his house to a beach. Mr. Soroken contends that the decision should be annulled because it is based upon findings not supported by substantial evidence in the record and upon errors of law. This is also an appeal of a decision by the Superior Court not to act upon the parties' cross motions for summary judgment on a preemption argument. I would like to first address the certiorari review. The Conservation Commission based its decision on 13 findings, but when those findings are reviewed, there are essentially 3 grounds for the dismissal. One was that the project was impermissibly on a coastal bank. 2, the project was impermissibly proposing clear-cutting vegetation in a buffer zone. And 3, there was a new structure proposed in a velocity zone where new structures are not allowed. Mr. Soroken contends each finding and basis is erroneous.
Can we take the last of those, please?
Certainly.
Is your argument that this is, as a matter of law, not a structure?
Yes, Your Honor, not a structure under the applicable regulations.
The regulations don't actually define structure, correct?
Correct.
So as I understand it, your argument then rests on some language that says structures, including, and then lists building, whatever, so 3 things, and this is not one of those. And that because it's not one of those, it's therefore not a structure.
That's part of the argument, Your Honor. It's a little bit more than that. So there's a part of the section of the regulation that creates what's called a presumption of adverse effect. And it says that new structures within a velocity zone are presumed to be adverse to the interest of this land subject to coastal storm flowage. But there's a little bit more to the argument than Your Honor cited. So there is that section that says new structures, and then it's followed by this phrase, including building sheds and garages and additions to substantial improvements to existing structures. And then there's another section right below that that says new shear walls or vertical walls for existing structures. And then there's another section of the same presumption that says foundations provide an adverse effect other than open pile foundations. And so our argument is that under statutory interpretation, the intent of this regulation and the meaning of this regulation is to prevent new structures that would impede the ability of land subject to coastal storm flowage to dissipate wave action. And I have an example for the court that I'd like to say. And I think it's one that's familiar for any New Englander that watches television. Whenever we have a big nor'easter, the news reporters on TV tend to go to this place in Situate where there's a vertical wall, and they stand in front of the wall and the waves smash into it with great drama and splash up into the air. That is what is prohibited because it is adverse to the ability of wave energy to dissipate naturally. However, this structure is not one that's prohibited because it's very much like another type of structure that we see on the news sometimes. And that's more down south, like in North Carolina or maybe in California, where you see a large pier extending out into the water. And when the waves come in, they just roll right through the pile structure. And so our contention is that when you look at the interests of land subject to coastal storm flowage, the interest is to allow these wave action to dissipate naturally without causing harm, but not all structures are prohibited, only those that interfere with the interests of the land. And we think the court can arrive at this interpretation through statutory construction. And we think that what the commission did was an error of law. And I would also point to one of the findings in the commission's decision. When finding that was a structure, they made a finding that this requires a building permit. And then they made a quantum leap and said, well, it requires a building permit, therefore it's a structure. And they didn't get into this more nuanced analysis that I've just given to the court.
But why is it that we wouldn't defer to the agency's interpretation of the regulation?
The case law does certainly say that an agency is entitled to deference when there are issues of statutory construction. But there is also case law that says the court is not to abdicate its responsibility. And when the plain meaning of the statute at issue arrives at another conclusion, or if it's not long and well settled, and or there are other parts of statutory construction cited in my brief, Nocerator Ocisius, if I'm saying that correctly, which says that when there is a word in context, it's to be written and construed in that context. And so again, I point to the language of the regulation, which says new structures, including buildings, sheds, and garages, new shear walls or vertical walls. And again, this is none of those. We think the commission made a mistake here.
Right, but the word including is different than, for example, the word such as.
Yes, correct. I would agree with that.
So structures is broader, as is, at least on the plain language as I read it, structure is broader than the three things enumerated after it.
Oh, I certainly agree with that, Your Honor. We're certainly not saying that the only structures that are prohibited are buildings, sheds, and garages. I presume there can be other types of structures, but I would submit to the court that this Falmouth Conservation Commission permits houses to be built in land subject to coastal storm flowage if they're raised on piles. And so this walkway, which is raised up on posts, is very similar to types of structures that are allowed under this regulation.
All right, but in the absence of a definition of structures, why is the fact that this particular structure required a building permit not a permissible consideration for the commission to take into account in determining whether this is a structure?
Because the word structure has to be written, without due respect, it has to be read in the context of the purpose and the intent of what this regulation is supposed to do. And I quote the regulation at length in my brief, and I've kind of already said it. I don't want to repeat that with my time is limited. But the point of land subject to coastal storm flowage is that it's an area of low-lying land that is inundated when there's a hurricane or a nor'easter or something like that. And the idea is not to have a building with that vertical wall, like I described of the Situate situation, because the waves will hit that building. It will knock the building off its foundation, and it will send the debris into the water, and it will become flotsam and jetsam and potentially hazardous to other structures in the area. However, this is not that type of structure. This is a type of structure that is expressly allowed, because if you look further down in that regulation, and it's in the record, it specifically allows foundations of an open pile nature. And so this is a structure that's allowed. And we believe that the commission kind of got off track, for lack of a better way to say it, by simply saying, well, it's a structure, it needs a building permit. And they didn't look into these deeper things, and they ignored their own regulations, which allows open pile structures. Those are in fact allowed, as I've said.
Attorney Wall, I have a question about the summary judgment issue.
Certainly, Your Honor.
As I understand the defendant's argument, or the appellee's argument, it's that the commission's decision rested on three independent grounds, but that your summary judgment motion raises a preemption challenge only as to the third reason. I guess my question is, number one, is that correct? And number two, if that is correct, and we were to determine that either of the other two grounds, for lack of a term, were independently sufficient, what do we take from that?
The town would win, in the short answer, Your Honor. So as I'm sure Attorney Mullen will say, it's the appellant's obligation on appeal to show that all of the reasons are wrong or erroneous for one reason or the other. The commission's denial, if any of the reasons survive, should be affirmed by the court. So the purpose of the summary judgment motion was to basically belt and suspenders. So we have under certiorari review an argument, and the summary judgment goes to the coastal bank issue. So we have made an argument under certiorari that the coastal bank findings are wrong. And in fact, the Superior Court agreed. The findings in the decision by the commission state that there is 431 square feet on a coastal bank. And I've made an argument, if you look at the minutes, it seems to me that there's another provision, this land subject to coastal storm flowage, that prevents structures in a velocity zone. And they were determining how many square feet were in the velocity zone. And then when they wrote the decision, in my humble opinion, they conflated the two. And they said that there's 431 square feet of structure, not only in a velocity zone, but on a coastal bank as well. And under certiorari, we've said that that's incorrect. The Superior Court agreed with that. But in, I guess, to say litigation strategy, you use every tool that's available. There's also an argument, a collateral attack after, not certiorari, but declaratory relief. After Mr. Soroken's permit was denied, he appealed to the DEP. And the DEP issued a superseding order of conditions overriding the local commission's decision, allowing the project. And in doing so, it's clear that the DEP found no part of the project was on a coastal bank. And hence, the summary judgment was brought to attack one of the three reasons for denial.
Why couldn't that have been brought in as part of the motion for judgment on the pleadings?
I'm very glad you asked that, Your Honor, because I think if you look at the Superior Court's decision, I was counsel in the lower court too, and the Superior Court seemed to be calling me out saying counsel argued this or counsel argued that. It's in the nature of how these appeals occur. They occur sequentially. A project proponent such as Mr. Soroken has to start at the local conservation commission and obtain a permit. Only after there's a decision is the right to appeal become ripe to the DEP. And so in this case, there was a denial decision. Mr. Soroken filed his appeal and he got his superseding order subsequent to all the Conservation Commission's proceedings. The only way to get that before the court is by summary judgment, because by its very,
Couldn't you have, doesn't that decision go back to the Conservation Commission as well?
No, Your Honor. With all due respect, what happens is I think you were about to ask me, shouldn't I have filed a motion to expand the administrative record? Well, the answer is no, because by definition, the administrative record is the record of proceedings before the Conservation Commission. And those proceedings came to an end with its decision. And that decision gave right to file the appeal with DEP. And so by its very nature, the DEP's decision always comes out afterwards.
I understand it comes out afterwards, but it preempts part of the decision of the Conservation Commission, which they would get notice of, wouldn't they? It would go to them. It would become part of the same record, but it didn't happen. But you're saying logistically, you did not believe that you could do it that way, even though, as the appellee points out, you received that decision before you filed your motion for judgment on the pleadings.
I think it might have actually come out a few weeks later, but that's not a point that I'm arguing. I'm arguing the bigger picture is that when a project proponent receives a superseding order of conditions that arguably preempts all or part of the decision, the proper way to present that to the court is by way of summary judgment or declaratory relief, because by its very nature, it's not part of the commission's proceedings. To say it another way too, when a court exercises judicial review, from the commission's point of view here, it would be unfair to the commission, arguably, to review it based upon something that happened after its proceedings concluded. And so I've had these cases before. The commission always resists the idea that the superseding order is allowed into the record because it happens afterwards.
All right.
I see my time is running short. I have less than a minute left. I think at that point, I'll just rest on my brief if there's no further questions.
Let me check. I don't see any. Thank you very much. That was very helpful to us.
Thank you very much, Your Honors.
Attorney Mullen.
Thank you, Your Honor. Good morning, and may it please the court, Irene Mullen for the Falmouth Conservation Commission. This case, as you have discussed already with Attorney Wall, has three independent grounds on which the project was denied. There is, as you discussed, the structure in the velocity zone. There is also a very substantial no disturb buffer zone, a zone A area that is an independently protected resource area under the bylaw. This is different from the State Wetlands Protection Act. It is more stringent and it is not challenged as a preemption issue. Attorney Wall mentioned that he believes it is error for the commission to have found that there would be clear cutting. I want to note for the court that that is a term that Attorney Wall has supplied. The term that was used in the decision is clearing, which I believe to be substantially different. The vegetation in question in these areas is about 15 feet tall for a large part of it. The area that is closer to the water in the area of the proposed platform is dune grass, so that's significantly shorter. But a lot of this is dense, woody shrub vegetation of about 15 feet tall. Clearly, to put in a walkway that is at max 2-foot elevation off the ground, there's going to be significant clearing, i.e. removal of large portions of those shrubs, and that will remain permanently. The applicant's proposal, the landscape designer proposed to flush cut those bushes, and Attorney Wall argues that they may in fact grow back. I believe it's within the commission's factual expertise to understand that there's going to be no significant regrowth of a 15-foot bush that is underneath a 2-foot high walkway once it has been flush cut. So there is a significant disturbance of vegetation in the buffer zone. There's also a disturbance of vegetation where this platform is proposed to go in the area which Attorney Wall describes as a swale. It's a, as he puts it, a gap between two coastal banks, very close coastal banks. The commission found that that area was part of the 2 adjacent coastal banks. Attorney Wall argues that it is not. The DEP decision issued without a finding that that area is coastal bank, but it is very clear that that area is within the buffer zone to land under ocean, coastal dune, coastal bank, beach, and the coastal bank no disturb zone extends almost all the way to the top of the boardwalk. The regulation that affects that is that if it is, it's FWR 1018, the buffer zone regulation states that if it is in a naturally vegetated condition, which it's undisputed in this situation that it is, the most of the area between the residence and all the way down to the water is densely vegetated. And where that is the case, the regulation states that there shall be no alteration, there shall be no work in that area. And this is nearly 1,000 square feet of timber being put in along that area. Turning to the structure arguments, Attorney Wall has pointed you to FWR 1038-3, which is the rebuttable presumptions, and he points to provisions about vertical and shear walls. And I would argue that he is conflating 2 things that the regulation is addressing. Certainly, the regulation does care about the issue that he raises about the vertical wall smashing waves into the air on television. That absolutely is something that the commission cares about. But there's 2 standards that are inside of this regulation. One is for new structures. The other is for reconstruction of existing coastal structures. There are a lot of houses in Falmouth that are right on the water in velocity zones that didn't used to be velocity zones and have recently become velocity zones because of erosion. And those people have vested property rights to perhaps elevate their homes to get them out of some of the worst flooding when these storms do come in. So in that case, they talk about no new vertical or shear walls on existing structures, on expansion or reconstruction of existing structures. There is no discussion of vertical or shear walls with respect to new structures. Similarly, he turns to the foundations and open pilings provision that prohibits typical foundations and requires open pilings. That applies to existing structures with a vested right to rebuild. They're not going to allow someone to put in a 14-foot tall block foundation and instead are going to require that the building be elevated on pilings so that, as he describes, waves can roll through. But that is only a risk that the commission has taken within these regulations for vested property rights for people that are in their homes already. It is very clear from the regulation that they differentiate new structures, and there is no limitation that can be reasonably read into the regulation, that no new structures are acceptable if they're on pilings. Attorney Walls said that the commission allows houses to be built on pilings. Those are certainly not new structures. The commission has never allowed a house to go in where there was no house previously, just merely because it is on piles. That is not the way that the regulation has been consistently applied since it has been put in. And one of the textual clues within the regulation that supports this is the fact that there is an explicit exemption for dune fencing for restoration purposes. If open piling structures were allowed as of right and not prohibited by 1038, there would be no point in having a dune fencing exception for restoration. So I think that also points, Your Honors, to the reasonableness of the commission's interpretation. But even assuming that the plaintiff's position is a reasonable reading of the regulation, which I submitted is not, it would still not take the day because as so long as the commission's own reading is reasonable, it's entitled to deference. And I think that's the situation here. I would like to turn, if I may, to the issue of the preemption summary judgment versus judgment on the pleadings. I would like to direct Your Honors to Hobbsbrook Farm versus the Conservation Commission of Lincoln. That's a 2005 appeals court case that is cited in the plaintiff's brief. That in fact was a case that was decided on judgment on the pleadings of a certiorari claim with a preemption issue. In that case, the administrative record had been expanded to include the DEP superseding order of conditions solely for the purposes of establishing that it had been issued. There was no substantive consideration of the internal merits of that DEP decision. It's just a fact. And that came into the administrative record. The trial court held that there was preemption. It went up to the appeals court, which reversed and did directly substantively rule on the issue of preemption, finding that there was none. So to me, that indicates that that is in fact a correct procedure upon which to address this issue. It certainly avoids—
That was a certiorari action?
It was a certiorari action.
Was there a declaratory judgment claim asserted?
There was not in that case, no.
Does that make a distinction here?
Certainly, I think it's possible for anyone to add any extra declaratory judgment claim to any case that they file, but in terms of the appropriateness of a judge deciding that the issue should be combined into a single motion, I think that it's supported by the case law in Hobbsbrook. And I think it also is supported by a rational understanding of what is the point of summary judgment. So summary judgment is at the trial court judge even cites the case Gloucester that talks about the fact that in the first instance, the question is there an issue of disputed fact before going on to the law? There's never going to be a disputed fact about the issuance of a DOC unless a party is asserting that the other party is fraudulently misrepresenting the fact that the DEP has or has not taken an action. It's not a question of what is the procedures that were followed by the DEP or any of the administrative parts of that. It's just, did a decision issue? Is this the document? Okay. And if you turn to the statement of material facts for the summary judgment motion, you see this. There is no dispute. It recites the administrative record, portions of the administrative record, and then it states, and there was a DEP decision issued, and this is the document.
And I take it that the town is not disputing the legal proposition that the DEP order of superseding conditions supersedes the Conservation Commission's determination, at least with respect to Coastal Bank.
The town does not dispute that the definition of a coastal bank within the Falmouth Wetlands regulations is, for all purposes relevant to this case, identical to the CMRs. The way that activity on that bank is regulated is much more stringent by the commission. So it's not that the CMR coastal bank regulations per se preempt the local regulations on that subject, but as to the existence of a coastal bank, yes.
But for other purposes, you're agreeing that the whole issue of summary judgment becomes moot based on the other two conditions having been.
Right, and I believe that's reflected in the judge's decision that there was no need to go there. There's no need to waste time writing yet another decision on an issue that's been mooted. And in fact, you know, once a summary judgment issue, once there is no live issue for adjudication, once there's no actual controversy, there would have to be a showing of a reason to address it, that it would be replicated in the future, that it would evade review. And there has been none in this case. So I believe it actually would have been improper for the judge to actually reach the summary judgment motion once she determined that the first two independently sufficient reasons to deny the application were found in the motion for judgment on the pleadings. And I think that's my time.
Are you suggesting we would do the same thing?
Yes.
I mean, is improper really the right word, or that that if she had decided to reach it and then she could have come to a completely identical conclusion, or the judge could have come to the identical conclusion? I don't know that I would agree that with your argument that it would have been improper for her to consider the summary judgment papers as opposed to it's unnecessary.
I agree that it's definitely unnecessary, but I don't believe that there has been a reason shown in this case to address something that has become moot.
I'm all set.
I think we understand your argument. We appreciate both of you. It's an interesting case and your arguments have been extremely helpful to us. So thank you. We're going to take the case under advisement.
And we are live.
Good afternoon, everyone, and welcome to this Zoom session of the Massachusetts Appeals Court. This argument is being conducted in this fashion because of the ongoing pandemic, and we greatly appreciate your help in allowing for that to happen. We are your panel for this case. It is my great privilege to be joined by Justices Neyman and Justice Lemire, and my name is Gabrielle Wolohojian. I just want to make a note that you are at all times during this argument going to be visible and audible, unless, as I see you've both done, you've put yourselves on mute. This argument is being recorded. It is being simultaneously broadcast on a YouTube channel that is accessible to the members of the public, and it will be stored and available in the future for members of the public to observe. Although we are conducting the argument in this fashion, the ordinary rules of our argument in our court are in place. So each side will have 15 minutes to argue, and there is no rebuttal. And with that, I'm going to call the case 2019 P0587, Old Colony Historical Society versus Taunton Church Green Realty LLC. And I hope I don't mispronounce your name, but Attorney Funka?
Funk, thank
Funk.
you.
Attorney Funk, we're ready whenever you are.
Thank you, Your Honor. The briefs that I have filed, both the in chief and the reply brief, I have nothing to add to as far as the case in chief. We are having this argument, from my point of view, primarily so that I can make clear the connection between the motion to strike certain portions of the appellee's brief and mainly the issues in count one. And
Attorney Funk, for my benefit, because there's no complaint in the appendix, can you tell me what count one was for?
Oh, that is for, that is, one moment, please. What it is that maybe I can best do it this way. If we could open up the record appendix at page 26.
Yep, we sure can do that.
That's the map, correct?
Yeah.
That's correct.
And before you get there, Attorney Funke, because I do want you to answer Justice Wolohojian's question, but maybe another way to ask this question is, do you agree that your 3 counts are properly delineated by the judge in his judgment at record appendix page 37?
Yes, certainly. The map shows the plaintiff's land outlined in yellow. It is lot number 66-433. And the defendant's land is outlined in red, consists of 2 parcels. One is lot 66-424, and the other is 66-426. And in 1926, the then owner of the plaintiff's land and lot 66-424 they were both owned by the trustees of Bristol Academy. At that time, the Academy trustees sold the rear portion to the predecessor in title of the defendant. And because there's no access to the public way known as Church Green to what was cut off, there was provided in that deed a very explicit right-of-way, 40 feet wide, with various specifications that is shown on this plan as in green, and that runs over the plaintiff's remaining land. And in 1960, the then owner of the rear land acquired an additional parcel, 66-426, which was cut off as because it was the backyard of Dr. Cooperstein, who retained ownership of lot 66-431. It is our contention. Well, I should start off by saying what we are not contending. We do not challenge the defendant's ownership of both of those parcels. We do not challenge their use of both of those parcels, either for separate uses or as to be aggregated for any particular integrated project that a future owner may decide they want to use it for. The only thing we object to is that the right-of-way that was bargained for as part of the 1926 transaction should not be used as access to the Cooperstein lot that was later acquired by some 30 years or so. So we're looking for a declaration that if that is to be used, the access to it should be by way of right of necessity over the remaining land of Cooperstein, which was 66-431.
Given the judge's findings as to how long the right-of-way had been used to access that lot, why is it that there hasn't become an easement by prescription, a prescriptive easement for accessing the later acquired lot?
Well, there's the rub, and there's the nub of our motion to strike, because the judge recited various evidence that was put in by way of testimony primarily as to what uses were or were not made, but the judge never actually made a finding of prescriptive rights having accrued. And the defendant tacitly acknowledges this when it says in its brief at one point, let's see, that the reciting the uses made of it, they say the defendant carried its burden of showing a right of way by prescription, except the judge never actually made a finding that a right of way by prescription had actually accrued. And the reason he did not, and it's rather explicit.
It appeared to me, I think, that the way the case was presented to the judge below was that the use, that using the right of way to access the Cooperstein lot was beyond the scope of the original easement.
Yes.
And I think the judge analyzed that issue in that form, and that may explain why he did not make an explicit finding of prescriptive easement, but rather talked about the issue as one having to do with the scope of the original easement.
I think that is probably so. That is exactly my point. I think the judge acknowledged.
Attorney Funk,
he did not make a finding that a prescriptive right accrued, because he went on to say that in my interpretation of the language of the easement on record, it authorizes and contemplates that it would be used for such a purpose. And my argument is that there is nothing in that easement of record that suggests anybody was thinking about it. I think the language of the easement in the deed wasn't just a casual drafting of a deed and adding a sentence saying, together with a right of way to over the grantor's remaining land to get to Church Green. They were very explicit, and they were looking to do two things. One was to describe in the most expansive way possible what rights the grantee would have to go back and forth. And second of all, they were trying to, as a separate matter, be very explicit about what physical activities could be done to change the physical character of the land over which the right-of-way ran. So they were explicit about utility lines, sewer lines, telephone poles, and grading, and so forth. There was, the judge made no finding about anything else. There was no no one who was carefully drafting this easement was thinking in terms of, oh, we better say that we're explicitly not going to allow this to be appurtenant to a after acquired property, because for generations, centuries, it's been a well-settled law that this doesn't apply. And so
I'm sorry to interrupt you, but let me ask you a question. If I want you to assume that the judge did not specifically, as you say, determine that an easement by prescription accrued, he did not make that ultimate determination. But assume that in his findings of fact, he found the prerequisites of an easement by prescription. He made a determination that the use had been open, notorious, and sufficiently pronounced for a period of 20 years or more. If such findings of fact are in the record, under our de novo review, are we allowed to address that issue and make a determination whether or not an easement by prescription exists here?
I suggest that that would not be appropriate, Your Honor, because if that were a possibility under the issues raised by the appeal, then the briefing would have been entirely different. And that issue has never been raised before this at all. That is a complete blindsiding to me.
Okay. It was raised in the trial court, is that correct?
I beg your pardon?
The issue was raised in the trial court, is that correct?
The issue of
a prescriptive easement?
A prescriptive easement. And there is no way for us to know what the judge could or would have done. But it seems to me that that is something that is for the trial court to do on the basis of his view of the credibility of certain witnesses and so forth and so on. And that's, it is not part of this case on appeal. I suggest that the judge was being careful to recite all of those pieces of evidence as to use, not for the purpose of buttressing any finding of prescriptive rights, but merely to show that in his view, some of these uses had such a nexus to the main portion of the property that it is somehow within the scope of the grant of the easement. And I'm suggesting that that is an entirely different, from a technical point of view, than reciting it for the purpose of saying, oh, well, this supports a finding of a prescriptive right.
I think we have to leave it there. Your time has expired.
Thank you very much, Your Honor.
Thank you. And we're going to hear now from Attorney Neyman.
Thank you, Your Honor. Just to briefly touch on the motion to strike, to the extent that's being argued, obviously, we believe that motion should be denied, just on the fact that the paragraphs that are sought to be stricken fall in the argument section. They're not in the statement of facts. And in the argument section, pursuant to Rule 16A9, the argument section is specifically for asserting your contentions. And the contentions are just your positions on the matter. The contentions themselves don't need to be backed up with things on the record. So to that extent, sorry.
Can you tell us where in the record we would see that the defendant had made the argument that of an easement by prescription down below?
I believe the references in the motion, or I'm sorry, in the brief were all to, I believe it starts on page 19.
No, but in what was submitted to the trial court, did you argue that you had an easement by prescription down below? And where will I find that in the appendix or in the record?
I believe that was an argument that was presented to the court, but I don't believe there was a request made to the court to determine that there was a prescriptive easement.
Okay, and you would agree that judge did not reach that conclusion in his findings and judgment?
I would. My contention with the motion to strike is only that the sentences to be stricken are merely contentions which are allowable under the.
Okay, and how do we reach that issue in the first instance here?
I don't think that I think that it's a little bit of a getting off track to talk about the prescriptive easement when the request, I always like to go back to where did this start? The original request by the plaintiffs was for a declaration that the Taunton Church Green can never use the right of way to access that after acquired parcel. What the judge found was that the Taunton Church Green can use the right of way to access that parcel based on the specific grant in the easement, which allows for uses of the way for various purposes associated with 424, lot 424. We have to frame this not in a vacuum, but in terms of what the actual property looks like. So in this case, 426 is not some separate lot that has no connection whatsoever to the 424 lot. If you look at the map, and what the judge found was that lot 424 encroaches essentially onto 426 to the extent that the judge found there's stairs that go from the building onto that lot, that there's a private entrance for a doctor's office there, that the paving on that lot allows for one to go from 424 to the area that would access that private lot, that there's a dumpster there, that there's picnic tables, and that there's parking there for access to the private entrances on that side. So it's not some separate lot that's just added on for no reason, and it's going to be a concert facility and we're going to have some extra stuff happening there.
We understand that we have a pretty good grasp on the facts of the case in the background. I understand what you're saying. But to get back to Justice Wolohojian's question, the judge found in your favor with regard to access to 426, to lot 426. But you don't seem to be arguing in your brief that the basis for the judge's determination was correct. Instead, what you're saying is there was an easement by prescription. So am I summarizing your argument correctly?
I think the argument has two parts. I think there is grounds for a finding of, based on what the judge found, there are the elements clearly presented and tried and found for an easement by prescription. I think the second part of the argument is that even without that direct finding, the judge did find, and I don't believe it's being disputed, that these uses that Taunton Church Green are using the access way for are proper under the specific grant for various purposes.
Okay, so where does that get you for the future? Because as I understand it, we're not, the proposed use doesn't have to do with this medical arts building. And so how do the judge's findings pertain to a future redevelopment of the two parcels unless there was a prescriptive easement? Because wouldn't it be fact dependent to know whether or not the future proposed use falls within the scope of the existing or original easement?
I think that would depend on what the new use was to be. And I don't think that we have it in our abilities here today, when simply addressing whether or not the judge's findings were correct, to look into the future and think about how these uses may work if perhaps the building was torn down and you don't have the encroachment anymore.
So as the case was presented to the judge below, and as the judge decided it, this ruling doesn't necessarily determine whether the future proposed uses will be within the scope of the easement.
Assuming that the future proposed uses would not be for a building of this nature that would need access to the other property for the parking lot and the access points, all the things that the judge found were allowable uses, then I think there may be a discussion to be had down the road about what the available uses are when, if and when trying to sell this property, what can this property be used for? And I think that it's very clear that in the grant, the specific grant, which as Attorney Funk pointed out, was crafted very specifically, it states exactly that the use can be, that the way allows for uses, various purposes associated with lot 424. So as long as it's within the scope of using that for the purposes of lot 424, it's within the scope of the specific grant.
Right, but you would agree that the judge's current decision is not binding or does not foreclose a future determination or determination as to whether a particular future use remains within the scope of the easement?
I would agree with that.
That actually begs a couple questions for me, which one is, you state in your brief that in 2017, the Taunton Municipal Council denied a special permit for 68 Church Green and lot 66-426. That denial was appealed. Where was that appeal to, and what is the status of that appeal?
I would have to confer with my client on that. I'm not sure. I wasn't involved in this original action, but I'm happy to confer and get that answer for you.
Okay, and then going back to the easement by prescription argument, are you saying that the judge's findings of fact are clear and unambiguous as to each element required for a prescriptive easement?
Yes, I think it could be found based on what was presented at trial, and the fact that the judge didn't reach that, I can't speak to, but I believe that there were presented enough facts and evidence to make that determination.
But how is it that if the use was at all times within the scope of the easement, the terms of the grant of the easement, there can be a prescriptive easement?
I think it's a two-prong where if the judge were to find, or if this matter became another issue, let's say in the future, as you propose, there's a different use used, and that is addressed at that time, a prescriptive easement would allow for that use, a use beyond the scope. In addition to that, there would be the original uses that are set forth in the grant. So it could allow for extended use beyond that.
Are you asking us to find, as a matter of law, that there is a prescriptive easement for the use over for the easement to be used to access 426?
No, sir. I am asking for, Your Honor, I am asking for the court to uphold the current judgment as it stands.
Which you would agree does not find a prescriptive easement.
It does not appear to me from the actual rulings of law that the judge specifically delineated that a prescriptive easement exists. I do believe there's.
It's just that your brief suggests that it does, and it is asking us to uphold that. So the confusion that we may be displaying here is based on the wording of the brief, I believe. I don't mean to speak for all three judges, but that's where I see the confusion, that your brief is suggesting we uphold the judge's finding of a prescriptive easement when we don't see that the judge ever found a prescriptive easement. And we're not trying to pin you into a corner or make you say something you don't want to say, but it seems as though you're agreeing there was never a prescriptive easement found by the court, the land court.
Agreed. I think that I do see how the drafting of the brief could trend in that direction, and I don't think that Attorney Swanson, when she was drafting this, intended to put onto the appeals court such a request. I think it was more framed, as I read the brief and as I would argue it, it was more framed in the narrative of the judge found correctly that these uses were proper, and that even if there was some argument to be made that these uses were outside the scope, there would be still an argument to be made and to be heard and found on a prescriptive easement. I think it was more, she was reaching for a global understanding of this to explain that this has been the use for a prescriptive period of time, and all of the elements have been found, although the judge didn't reach that. And what we're here today to argue over is whether or not this ruling should be undone, and it should not. The ruling as it stands was a proper within the law and is supported by all the facts on the record.
Hypothetically, truly hypothetically, if we were to find that the judge's decision is not supported, but that there may be a prescriptive easement, is the correct result a remand? And as part of that question, I think you need to take into account Justice Wolohojian's question, which is, do we have any information that shows us that the prescriptive easement request was actually made before the trial judge? Or the argument that there was a prescriptive easement was made before the trial judge?
I would have to go back to the, to listen to the trial record and to hear and see what Attorney Swanson brought before the court. My understanding is that it was a request that was put on the record, but I would not be able to point you to that specifically right now because I wouldn't have that available to me.
But you do understand that we're bound by whatever record has been put before us on appeal.
I do. And I think it's all there. And if it were to be a decision to go back, you could find a prescriptive easement in the records. I believe that if you were so inclined.
All right, I think we understand both your arguments. They were helpful in this extremely interesting case. So we thank you for them. And